Page 26.
Hey, what's up, everybody? Welcome back to the internet where your cesspool is my jacuzzi. I'm here with Bruce from Oregon and Snittle Ninja. Bruce from Oregon for I don't know how long because he's going to be in a van somewhere else at some point. But we're going to read the appeal brief or the response to the appeal brief from Clayton Echard in response to Laura Owens' appeal. Snittle Ninja was going to read this on her channel as well. So if you just want to hear a straight read through, it's going to be on her channel. I think it's taking a while to upload, right? Okay, so you can always go there and listen to that as well if you want to hear it without me clowning in between pages or paragraphs or sentences even. But here's the website. I'm going to post and link to the whole website that the response brief is actually posted on right now. It's called victimsoflauraowens.com. So it's also, I think it should be in the description of this video. If it's not, I'll put it in there later. But I'm going to put it right here. And I'll go ahead and pin that. Give me one sec. Tell me I'm on the right page. There it is. Yeah, I'm going to pin that real quick. And you guys can read along if you want to, or, read it on your own time. I don't know if you don't want to listen to me talk, but why wouldn't you? So, meow, I guess. All right. So, I'm not showing it on the screen yet, am I? Give me one sec. There we go. Hopefully is that big enough for you guys to see?
Yeah.
All right,
yeah, it looks good.
All right, so we're going to start on page 6 here with the statement of the case. This somewhat unusual case comes before the Court of Appeals following paternity litigation without a proven pregnancy or even credible evidence of intercourse that could have produced one. Although the opening brief makes sweeping claims of jurisdictional deficiency and judicial misconduct, the core issue is whether a person may, 1, file a petition alleging paternity, 2, fail to provide objectively sufficient proof of pregnancy, and 3, oh no, there's more than 3. 3, tamper with evidence and lie under oath, and 4, opt out of the litigation consequence-free. The trial court determined that Laura Owens could not do those things without making Clayton Echard whole for the fees he incurred to defend himself. This appeal followed.
Sounds good so far.
So, in the video earlier today, the lawyer for Laura Owens said that they were going to request oral argument. Is that right?
Yep.
Okay. So how does that work? It's like a short hearing or something.
It's 30 minutes each side, and then I guess the judges would make a decision after that. Obviously not that day, but.
Okay. Yeah. All right. Statement of facts and procedural history. Because this court generally defers to the findings of fact of the trial court, and most of the factual findings are not challenged, Clayton will provide a non-comprehensive summary of the facts and history. Additionally, although there were 2 companion actions, an order of protection and an injunction against harassment that occurred during the underlying paternity action, they are only discussed to the extent relevant to the judgment in this case. On May 20th, Laura performed oral sex on Clayton. God damn it. Okay. On August 1st, Laura filed a petition to establish paternity, legal decision-making, parenting time, and child support, alleging she was pregnant with Clayton's twins after the May 20th sexual encounter. The trial court found the sexual conduct did not result in pregnancy. And this is HCG test, it says. Okay. Oh, what the heck?
We've gone off the rails.
All right, there we go.
Yeah.
Laura has a medical history of diagnosed conditions that affect the likelihood of pregnancy, including epilepsy, polycystic ovarian syndrome, PCOS, and ovarian cancer. Don't allege that you have ovarian cancer if you can't back it up later. All right. Laura has had PCOS since the age of 17 and does not have a regular menstrual cycle. On May 31st, Laura allegedly took an at-home pregnancy test, which apparently showed the presence of human chorionic gonadotropin, HCG. I'm not used to seeing that whole word in her urine. This was the 4th time she has tested positive for pregnancy in her lifetime.
Gonad.
What?
Gonad.
Where?
Gonadotropin.
Gonadotropin, yeah, okay. All right.
Welcome to chemistry class.
You're a child.
I know. I can't help it.
All prior alleged fathers believed she fabricated the pregnancy and doctored medical records. Imagine like somebody having to write that in a document about you. Like,
Oh dear.
that is
Crazy.
miserable. Okay. On June 1st and June 19th, additional urine tests showed the presence of HCG, one at Banner Urgent Care and another completed at Clayton's home. What does EP5 mean? Help.
Where?
Right here where it says
Well, there's
EP5.
an EP4. So there
I see EP4 up here, yeah.
these may be indexes to other material.
Okay, got it.
Yeah, exactly.
Okay. On its own, the presence of HCG is not determinative of pregnancy, which requires confirmation from a medical provider through an ultrasound or other verifiable objective evidence. For example, giving birth. Alternative reasons for the presence of
idea.
HCG in blood and urine include epilepsy medications, anxiety medications, clozapine, horse urine. Oh God, no. Oh God, the image. Fertility treatments like IVF trigger shots and cancer. So there's a whole lot of stuff there that could be causing that. So if
Yeah.
you were a person with all these conditions or with all these things that you were taking, even horse urine, I guess.
Is this even a
then-
comprehensive list? I think this is just
Probably not.
this
no.
is just a partial list of
Right?
potential reasons.
On October 16th, Laura allegedly obtained a blood draw, which indicated her HCG levels were 102. Laura changed the results to reflect levels of 102,000. Both medical experts, Dr. Deans and Dr. Medchill, confirmed that an HCG level of 102 indicates a non-viable pregnancy. Even with this information, on October 18th, Laura requested pre-decree mediation, claiming that Clayton acts as if the unborn children don't exist, despite a preponderance. I think she means preponderance. Is that right?
Yeah, and in her lawyer's video today, it seemed like he was calling out the typo, like thinking it was Marcus, and it was actually him quoting
Oh,
Laura.
Because it's a quote.
That's
That's why you
awesome.
put sick,
Right.
is because you're indicating
Right.
somebody else made a typo.
Yikes.
I mean,
Alright.
I don't know. It's a type. Okay, we all make typos. It is kind of a funny typo.
It's not even a word.
Management best practices how to type. I don't know.
Just sound preponderous. I mean, I think her litigation is preponderous. We've invented a new word.
Oh man. All right. Additionally, on October 24th and November 2nd, Laura testified before Judge Galketsis that she had a high-risk pregnancy, was 100% 24 weeks pregnant, was due on February 14th, 2024. She had to pick fucking Valentine's Day.
Good old
didn't she?
Valentine's
course.
Day.
And this was again on October 24th and November 2nd. So let's, again, as a reminder, on October 16th, she got an HCG test that indicated a non-viable pregnancy. And was being actively seen by Dr. McCool and Dr. Higley, who she saw last Friday. I can't believe she still tries to defend that. Like,
Good old Dr. Higley.
on October 25th, 2023, Laura testified before Judge Duty regarding the validity of the sonogram sent to Clayton and that she believed she was having fraternal twins, one boy and one girl. Well,
Oh,
your
dear.
lawyer went ahead and let us know that you never got a sonogram to that effect. Sonograms, miscarriage, and medical providers. On March 1st, 2024, Laura testified that she obtained a sonogram at Planned Parenthood that confirmed the presence of twins in July of 2023, and that she modified the image to falsely attribute it to Southwest Medical Imaging by altering the heading, name, and date of the sonogram. Laura alleged she obtained the I can't talk. One second. When I read too many pages, it's like, okay.
Yeah, and this is long. This is a lot of reading.
I'm going to try. Laura alleged she obtained the original sonogram anonymously at Planned Parenthood Mission Viejo on July 7th, 2023. Planned Parenthood does not accept patients using an alias. Patients are required to provide a government-issued form of identification.
Hmm.
And I feel like that's definitely the case because, like, if you can't tell them who you are, they're either going to A, turn you away, or B, like, if you seem like you're really out of it and you can't possibly explain, like, who you are or what you're doing there, they're going to send you to the emergency room. Like, it's not going to be, you're not just going to walk in and get services like that without ID.
I think the fact that you can't go anonymously and there's no provider that can find these mysterious sonograms is more important than whether or not any of them are open on Sunday, right?
Yeah.
Like, we don't even have to go there.
Yeah.
All right, let's see. Planned Parenthood does not accept patients using an alias. We got through that. On April 15th, 2024, Laura claimed the original sonogram was from a visit to Planned Parenthood Costa Mesa on July 2nd. Okay. On March 18th and April 17th, 2024, Clayton sent HIPAA records requests to Planned Parenthood in Orange and San Bernardino, I can talk, counties, which denied having any sonogram records for Laura and noted the alleged sonogram was not consistent with ultrasound images generated by their practice. Then, for the first time at trial on June 10th, Laura testified that the sonogram was from a visit to Planned Parenthood Los Angeles on July 2nd. Laura claimed this was the reason Clayton was unable to obtain any records from the Planned Parenthood visits she previously disclosed. They were false statements.
Oh boy.
On February 21st, 2024, during a status conference, Laura stated she has miscarried sometime in September or October 2023. On March 1st, Laura alleged she passed 2 sacs which appeared to have a membrane in September or October of 2023. Laura later claimed she passed the tissue on July 23rd, 2023. Laura alleges she did not experience heavy bleeding and spoke with an online telehealth provider. There's a difference between an online telehealth provider, by the way, and a text hotline. So, okay. Who found it hard to tell whether Laura had a miscarriage and advised her to seek in-person care, which she did not do.
Yeah, I mean, if you were embroiled in this paternity case, wouldn't you, and you thought these sacs had any relevance to this case, wouldn't you take them to get them examined by a pathologist? Like, you could perform DNA testing, if nothing else. You could have clinical proof of miscarriage for your case. We have none of that.
Yep.
It's just a failure.
I don't know. I think she was pregnant with triplets.
Did you say gerbils?
Triplets.
Yes, that's what I said.
Gerbil triplets.
No, just gerbils. Just gerbils. All right. Okay. Read that part. Laura later claimed she passed the tissue on July 23rd. Laura alleges she did not experience heavy bleeding and spoke with an online provider. Laura alleges she took additional HCG tests on July 25th and August 1st, which were positive. Okay, but positive HCG test doesn't mean anything if the level is 1.
Yeah, you can have 1 million HCG tests, but what we need is fetal heartbeat and ultrasounds or babies.
Babies. That's funny. Sorry.
Something.
There were no babies.
1 HCG test, 1 million HCG tests. I don't care.
Right.
That's not the level we need.
All right. Laura made 4 appointments with Dr. McCool, a maternal fetal medicine specialist, in the month of August 2023. Laura rescheduled 3 of the appointments and canceled the 4th. Now, as people have pointed out before, it's like a really kind of a shitty thing that she did that when there are other people with actual high-risk pregnancies who need those appointments. So, in the injunction action before Judge Galketsis on October 24th and November 2nd, Laura testified she actively had a high-risk pregnancy, was 24 weeks pregnant, and due on February 14th, and was being seen by Dr. McCool and Dr. Higley, who she saw last Friday. We read this already, didn't we?
He quotes a lot of the same things throughout.
Okay.
Yeah.
Gotcha.
This is for context. I think the other thing is, like, if you have such a high-risk pregnancy and you're really pregnant, like, it seems,
Irresponsible.
Yes, it's irresponsible to move 4 appointments.
And to not have an established,
That's negligence. That's almost, I don't know, at least to a layman, that's criminal negligence.
And
maybe not legally, but
hasn't she tried to say that she wasn't planning on keeping them, but then people were like, but why file the parenting plan and take the class?
Yeah, I mean, there's a bunch of contradictions
Yeah.
with that I don't understand. Yeah.
All right, let's see. Being seen by Dr. McCool, Dr. Higley, who she saw last Friday. We read that, right? On October 24th, October 25th, and November 2nd, Laura was seen standing and rubbing what appeared to be a swollen abdomen in the OOP and IAH hearing. Laura's records show she was never treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist. On November 14th, Laura took 2 pregnancy tests done at MomDoc, which confirmed she was not pregnant. Disclosed to Clayton on 2/23/24. That's what, 3 months later? Jesus Christ.
Dang. What's the delay? What's going on in Arizona? Like, you have to wait
Going on
months
in the casita.
to tell Mr. Echard? What the heck?
All right. Paternity testing, boy and girl twins, and procedural history. On August 1st, Laura filed her petition to establish, alleging she was pregnant with twins. On August 21st, Clayton filed a pro per answer denying that Laura was pregnant with his children, denying intercourse, denying paternity, and requesting an award of attorney's fees pursuant to ARS 25-809G and ARS 12-349. Clayton moved to amend his response on December 12th and filed the amended response on January 26th.
Mhm.
On October 2nd, Clayton and Laura participated in paternity testing with Ravgen. Brett from Ravgen. On October 6th, the results indicated little to no fetal DNA, which you would think is enough, but no. On October 18th, 2023, after Laura learned she had no viable pregnancy via blood test, on October 16th, Laura requested pre-decree mediation, claiming that Clayton acts as if the unborn children don't exist despite a, again, preponderance of the evidence. Recall that on November 2nd, Laura testified to being 24 weeks pregnant with twins and due on February 14th,
Mhm.
i.e. weeks after she already knew she was not
Yeah.
pregnant, according to her narrative. On December 6th, the results of another Ravgen paternity test indicated little to no fetal DNA. The results for a third test, why the hell would you even need a third test, were lost in transit.
Because the testing is ongoing.
Okay. Yeah, I mean, that's true. My bad. On December 12th, Clayton filed a notice of filing affidavit of non-paternity. On December 28th, Laura filed a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice, alleging she was not now pregnant with respondent's children. The court denied the motion to dismiss on February 14th because the issues of attorney's fees, costs, and sanctions remained.
There you go.
Okay. Well, that's kind of like where they keep doing the Rule 26 thing, where they're like, they dismissed it, but they didn't, right? Okay.
Well, there are pieces of litigation that you can dismiss and other pieces that
Right.
you can keep going, from what I understand.
Right. And she said on the video today that they dismissed it, then they approved it, and then they dismissed it. She said there were 3 parts to that.
Okay. So
But
what's
that's
the
not
problem
that's
with
not
the-
3 things on one piece of litigation.
That's what she was trying to say.
Well,
That for her to try to get the case dropped, that there were those 3 things that happened in that order. I didn't remember that, but
yeah. Okay. The court denied the motion to dismiss on February 14th because the issue of attorney's fees, costs, and sanctions remained. On January 2nd, Laura filed an expedited motion to quash deposition, which the court denied after briefing. On January 3rd, Clayton filed a response/objection to Laura's motion to dismiss and a motion for sanctions pursuant to Rule 26. Laura did not appear for her first scheduled deposition. On January 17th, Laura filed a motion for confidentiality and preliminary protective order, referencing a miscarriage for the first time. That was, oh my God.
Yeah.
What a desperate move to try to, because of course people are going to know she's not pregnant if they see any part of the records. All right. On February 2nd, Laura deposed Clayton. And it's gross that she was there in front of him and shit like that, but I feel bad for him. Especially that they published part of his depo on YouTube and stuff like that. How do you think they would feel if Woodnick published part of Laura's?
well, of course they would be it would be yeah.
And it's not necessarily about legality or anything like that, but it's just etiquette. It's just professionalism.
Yep, exactly. Because they could release hers right now if they wanted.
Yeah.
But her lawyer and she would give them so much shit for that.
Yeah, they would. And then it'd be funny because they already released Clayton's.
Right.
Still.
Clayton owns hers.
Some people actually, care about how they appear to other people in their profession, and some people don't. So here we are. All right. On February 2nd, the post Clayton, during the status conference on February 21st, Laura claimed she miscarried in September or October. With consent of the parties, the court advised it would review the IAH and OOP hearings, treat the motion to dismiss as a request for attorney's fees equally, and hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition. All pleadings filed within the Maricopa County Superior Court. Okay. On February 27th, a few days before her rescheduled deposition, Laura sent a letter to Clayton indicating she would sue him for approximately $1.4 million unless he agreed to unconditionally dismiss the paternity action.
$100 billion.
Oh my God.
Oh boy.
I forgot about that. I forgot.
Oh
my God.
The $1.4
that was
million.
wild.
Yeah.
Attempted extortion or whatever. Like, that's crazy. All right.
And then they said in the video today, he was like, well, you had to do it because like he did something wrong. And she was like, yeah.
Like what?
Didn't send the offer over to a coworker like he said. Like that's what they're saying.
Was a long fucking time.
I mean, I know. But that's what they were
saying. You already took
today.
that up with the real estate board. Like, what else? So you have to extort someone. How does it even make sense?
Oh my God. Also, how hard is it to just get a realtor and buy a house? Like, come on.
All right.
Like, move on with life.
She had an agenda for sure.
Mm-hmm. All right. Clayton deposed Laura on March 1st because Laura failed to attend her first. It doesn't say this up filing, but she failed to attend her first deposition. All right. For the first time, Laura stated she passed 2 sacks which appeared to have a membrane in September or October of 2023 and took a picture of them. Okay. Laura later claimed she just took a picture of them and was like, that's that.
These might be my babies. I took a selfie. Like, what the hell?
Right.
That is.
She's like selectively upset about the miscarriage too. The way she like smiled about it in the video.
So negligent.
Like, nasty. Yeah. All right. Clayton deposed Laura on March 1st. For the first time, Laura stated she passed 2 sacks. Laura later claimed she passed the tissue on July 23rd. Okay. So she said first September or October, and then it was July. Okay.
And he recaps that at some point in the document.
Okay, good. Because I'm like so.
It's like, when you're in Arizona, summer and fall, it all runs together in the weather almanac. I mean, it's who can tell whether it's summertime or fall? We don't know.
Oh my God. PMRYP, thank you very much. Yes, guys, if you could hit the like button, that would help me out a lot. All right. On March 11th, 2024, Clayton filed a motion to compel Laura to disclose the alleged Planned Parenthood records, the image of the 2 sacks, the name of the telehealth provider she spoke to on the day of the alleged miscarriage, and a file from a 2014 paternity case, granted for 9/24.
So now in their video today, do you want me to like tell you this stuff? Or yeah.
Oh, yeah.
They were saying that the lawyer said that the way that Woodnick filed the motion to compel, that's not the way it ever works, and it was so bizarre, and he's never seen anything like it. Jesus. But he didn't elaborate.
I mean, at least he's trying to compel evidence instead of just lunch.
Right?
I mean, that's a step up.
Eat with me.
All right. On March 11th, Clayton filed a motion to compel Laura to disclose the alleged Planned Parenthood records, the image of the 2 sacks, the name of the telehealth provider, file from 2014. On March 25th, Clayton filed a motion for joint hearing, granted 425, and an amended motion for relief from judgment based on fraud, requesting the court take additional evidence against the OOP Laura filed against him on October 6th. The latter motion was granted on May 21st, with the court reiterating it would view the recordings from both the IAH/OOP hearings to rule on the validity of the OOP and any award of attorney's fees at trial. On April 3rd, Clayton withdrew his prior motion for Rule 26 sanctions. On April 4th, Laura filed a notice of non-objection. The court accepted the withdrawal on April 4th, but did not distribute the order until May 16th due to a clerical error. Okay. And isn't that something he was bitching about for a while, the lawyer?
Sure.
I think I remember that. He was like, the judge's mistake is not my problem, or something like that.
Yeah.
And I just remember it was all, he was tweeting about it and shit like that. All right. On April 8th, Laura filed a motion to compel lunch and for alternative relief.
There it
Denied
is.
4:30. On April 12th, Laura moved the court to take judicial notice of Laura's prior lawsuit against another person, Greg Gillespie, whom she also impregnated her. Granted 426. Now, Greg Gillespie, as you guys know, was just recently served with, she's trying to renew her protective order against him, which is absolutely bogus. Greg has a fiance and a child. He wants nothing to do with her. So
like
it's absolutely
literally nothing. Like he does
Right.
not want to be a part of your life.
He never did.
Ever.
No, he never
Ever.
did.
Get the fuck away.
No, he's a good guy. He's a good guy, and I feel sorry for him, like that he's
Me
going
too.
through this. Not sorry in like a pitiful way, but just sorry that somebody would do something like this. You know what I mean?
Yeah.
On April 30th, Laura filed a motion in. Is it okay? How do you pronounce this again? I always say lemonade just for fun.
Limine. What if you're saying the Latin?
Okay.
Limine.
Limine seeking to preclude the testimony of 3 other men whom Laura alleged impregnated her in the past. Once with ovarian cancer and everything else going on. Right. On May 10th, Laura filed a motion for judgment on the pleadings and renewed motion to dismiss, which the court deemed moot and therefore denied on May 28th. On June 3rd, Laura's prior counsel filed an ethical rule 3.3 notice of candor, indicating that their statement at the status conference that Ms. Owens has not lied in this case was no longer true, considering Ms. Owens' deposition on March 1st.
Oh dear.
Love that. Love that for her.
That's a lot of denied motions.
Trial, final judgment, and post-trial filings. Okay. From May to June 2024, the parties the parties filed various chocolate. All right. If you don't know what chocolate means, then you should know what chocolate means. All right. The parties filed various other motions, requests, and statements in preparation for trial. I got my thing got copyright claimed the other day for the chocolate scene.
Did it really?
Yeah, not a strike. So like, there's a copyright strike where somebody like takes your thing down and you get a community violation from YouTube or whatever.
Mhm.
But a copyright claim, it's just like you can't make any money off the ads, basically.
Mm-hmm.
So
That happened to one of my videos too. It had like I Was Meant for You by Jewel in the background of like one of her horseback riding videos.
Yeah.
So I was like, I could have just like removed the sound. I didn't even think about it.
Yeah. All right. Let's see. The court held an evidentiary hearing on June 10th and issued its final judgment in the form of an under advisement ruling on June 18th. The UAR summarizes the history, the court's findings, the legal analysis of various issues presented, and the relief awarded with substantial detail. As to paternity, the court found it could not establish Laura was pregnant as a threshold matter, then further elaborated that Laura failed to meet the burden of proving Clayton was the father of the alleged pregnancy. The court granted Clayton's request for a finding of non-paternity. Was that because the actual DNA test said there was little to no fetal DNA, among other things?
Seems like it.
Oh my God.
Lack of evidence.
Yep.
The court also awarded Clayton attorney's fees and costs based upon ARS 25-324B and 25-415, with a 2-page explanation of the findings supporting the award. The court found Laura initiated the litigation without basis or merit, that her petition was premature at best and fraudulent at worst. That's a nice way to put it. And that Laura's explanation for requesting mediation after she already knew there was no viable pregnancy was disingenuous, misleading to the court, and perjurious.
Oh boy.
The court also found Laura repetitively failed to comply with Rule 49 by altering HCG test results, an ultrasound and a sonogram, 2, falsely reporting facts about her alleged Planned Parenthood visits, including a brand new disclosure at trial that she sought care at Planned Parenthood in Los Angeles. despite prior assertions and discovery being directed to other Planned Parenthood locations and entities. The court found Laura filed her petition in bad faith, that it was not grounded in fact or based on law, and that it was for an improper purpose. The court found Laura provided false testimony in all 3 cases against Clayton and unreasonably threatened to sue him for $1.4 million in collateral. I'll never forget that. No, I forgot it once, but I'll never forget it again. In collateral allegations, unless he agreed to dismiss the action Laura initiated. Lastly, the court found Laura knowingly presented a false claim and knowingly violated a court order compelling disclosure of discovery. So how did they read that and he's still like, I think we're going to win?
Oh my god.
To be clear, Laura does not challenge these findings on appeal. Instead, she asserts the court should have dismissed the case before she engaged in most of these behaviors, so they can simply be ignored.
Oh no.
Oh my god. That's nutty. Oh my god. Okay. After the ruling on July 8th, Laura filed a notice of change of judge for cause, memorandum, and affidavit in support, alleging the trial judge conducted an independent investigation into the facts via social media. After briefing, presiding family court judge Honorable Rhonda Fisk, that is a mouthful.
Yeah, it is.
Whoa.
I have so many. I had to make so many edits on my video, and some I just left in. I was like, I'm not fixing that.
Denied the notice, finding Laura did not present a prima facie. Is it facie? Is it facie?
Fascia.
Fascia. Okay. Prima, whatever.
Or facie, if you're saying it in Latin, or if it's the original
English,
Latin,
bitch.
it would be facie.
Oh boy.
Facie.
A prima facie. Yes, for bias or prejudice, and if such error occurred, it was harmless given the overall weight of evidence supporting the judgment. The same day, Clayton filed his application for attorney's fees and costs, which was granted on August 16th. After a timely response and reply.
Also, he said today that he hadn't thought of this before, but maybe Mata's sister is the one who told her about Planned Parenthood being closed on Sundays.
Okay.
That's his new theory.
That's well, that's different than the theory he presented to everyone. So okay.
To everyone.
I guess he decided that he was going to be a misogynist now, so it made more sense for him to accuse the sister, because maybe she's one of those grocery people in line reading the Inquirer. I don't know.
Why does he even need to speculate? Sometimes, it's
Because
reasonable to just say the answer is I don't know or we don't know. And that's fine.
But he does know, Bruce. He knows everything. Always. About anything. Ever.
No.
Ever!
Just say you don't know. I don't know. It's fine.
So is it primo facial?
Oh boy.
All right.
Let's
see.
Willy-nilly throwing people under the bus. Yeah.
On July 12th, and moving on, Laura filed a motion to vacate judgment, motion for a new trial. Alternatively, what? Okay. Motion to alter/amend judgment, motion for leave to exceed page limits, which the court denied on September 9th. Sorry, the court loves them. All right. On September 5th, Laura appealed from the order reapplication for attorney's fees and costs, seeking a review of all prior non-appealable interlocutory decisions, orders, and rulings made by the trial court, and she filed an amended notice to include the trial court's denial of Laura's motion to alter/amend, filed 9/9. Okay. Laura cites ARS 12-2101A1, appeal from final judgment, A3, appeal from an order affecting a substantial right that prevents final judgment from being entered, and A5A, that is weird. This is all weird to me, guys. Order refusing a new trial for appellate jurisdiction. So when I'm looking at this like A5A thing, I'm like, oh my god, this is like an alien language. Like, I'm honest. Like, I'll read the paper, but it doesn't mean I understand the format.
If you just think about a list, right, and you're going A, B, C, D, E, 1, 2, 3, 4, 5, it's just a way of finding specific things that people can do under the law, right?
Yeah.
So these are just indexes to help people when you want to go look these up, how to find them.
Yeah. All right. Well, I'm
From my
totally not
understanding.
going to do that, but I get it. Hold on, I forgot to set a target goal for tonight. Let's see. Share how you'll celebrate. How will I celebrate if I get my super chat goal?
Mm.
I don't know what to do. I'm not on the screen. I guess I could put myself on the screen, but like,
Do you have
why?
any alcohol?
Do I have what?
Alcohol?
I do. But
Take a
do I
shot.
really want to do? If we're doing shotsies, I gotta bump it up to 10 because.
Yeah, make it a big goal and do a shot. There
All
you
right,
go.
fine. Every time we reach 10 super chats, which hopefully won't happen at all, I'll take a shot of something disgusting.
You could share something not many people know about you.
I could, but then I would go to jail.
You have the chance for it.
All right, I have a no. We'll do for if we meet this one, that I'll take a shot of something disgusting. Then the next one, if I set another goal, will be I'll tell you something that I've never said out loud.
We could just, be happy that we met the goal, and that could be the celebration.
Yeah. But I have to I have to do the shot first, otherwise I can't tell you. Give me 1 second. Let me see if I can do that. I always forget about these things now. How long have these been around at goals?
I have
Like a few, not very long, just a few months. They've been testing them out. Not everybody has had access to them, so.
Okay.
Also, when you
maybe
set
that's
the
why.
time for them, the time starts when you set it, not when your video starts.
Yeah, I gotcha.
So if you create a video for 2 hours from now and you set a 1 hour timer, it'll be
that's fine.
done way before your video starts.
That doesn't make sense.
It's pretty weird. Yeah, it's set from the time you set the goal. Because I guess the chat room will be open,
Okay.
even if your video hasn't started. So it's theoretically possible.
Gotcha. All right. Where did we get to? I lost my place because I was busy talking about.
On September 5th?
Okay. On September 5th, Laura appealed from the order reapplication for attorney's fees and costs, seeking review of all prior non-appealable interlock. Oh, we read this. For
We
sure.
read this whole
We read the
paragraph.
bottom of
We're ready
yeah.
for the next page, I think,
right.
unless you
Okay.
want to.
Statement of the issues. Laura's opening brief argues 5 issues. Further references to the issues presented in the opening brief will be to the issue numbers.
This
Okay.
part's pretty good.
Nice.
Okay. Purple Dragon Chill. Thank you for the 5. That's 1. All right. The court has an independent duty to determine whether it has jurisdiction to consider the issues raised in appeal. I'm going to skip over that reference there. The appellate. I keep wanting to say appellate. The appellate court's jurisdiction is purely by statute, and that's been a thing forever. Like, I don't know why, but for some reason I'm like appellate, like the fruit, like apple it.
It looks like apple.
Yeah. Appellate court's jurisdiction is purely by statute. Okay. Blah, 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 blah. Oh my gosh. There's so many.
This is just him referencing like these things and what he's referencing, like the lines he's referencing from those.
Okay, I'm going to skip a little bit of that.
I imagine this is why a lot of lawyers don't like doing appellate work, because you're doing a lot of cross-referencing and citations, and that seems to be the bulk of that work.
Yep. And editing.
Yeah.
Most of the issues Laura presents for review do not arise from the final judgment. Issues 1, 3, 4, and 5 all arise from her argument that the trial court should have granted one of Laura's pretrial motions to dismiss. Denial of a motion to dismiss cannot be directly appealed. Ooh. But it can be reviewed on appeal from a final judgment only if it is an intermediate order involving the merits of the action and necessarily affecting the judgment. Okay. Argument. The opening brief does not prove error or establish grounds for reversal. The court awarded Clayton attorney fees as statutory remedy, not a Rule 26 sanction, making most of Laura's arguments categorically I've never seen this word before. Inopposite?
I looked it up. It's a word. I didn't know it either.
I was like, you mean impossible? What's happening here? Categorically inopposite.
Learn something new.
There is no safe harbor provision to avail a party whose conduct falls short of their duties under Article 49.
It means out of place, inappropriate.
Artful?
Nice.
I like
No,
artful better.
inapposite. Inapposite. Inapposite?
Inapposite? Inapposite. I'm talking about this thing
Inapposite?
down here, man. The
Inapposite.
ARFLP.
Inapposite?
An opposite.
Oh,
Yeah.
ARFLP is what? Arizona.
Federal law.
Winks, thank you for the $5. Winks says drink. Well, we're on our way now. That's number 2. Let's see. Deb Peterson says, "Did Woodnick write this?" No, it was Marcus.
Arizona rules of family law procedure.
Arfulp. Arfulp.
The good old Arfulp.
Deb Peterson, "Did Woodnick write this?" No, it was Marcus. Is it his last name? Is it Risinger? Risinger. Okay. No,
or Risinger. I guess it could be
Risinger.
I actually have no idea. So I'll take your word for it. Okay. There is no safe harbor provision to avail a party whose conduct falls short of their duties under Article 49. It's like a seal. It sounds like a seal.
Rules of family law procedure. I know, Arfulp.
Who knowingly presents a false claim or violates a court order compelling disclosure or discovery under ARS 25-415, or acts unreasonably under ARS 25-324 and 25-809G. The opening brief freely admits that Rule 26's safe harbor applies only to the conduct that allegedly violated that rule.
Also, sorry, I just want to add because I saw Cat Lady's message about Runkle. Also, she gave you super chat, which is great.
Oh, sweet.
So I believe Rachel Juarez is going to be sometime soon covering this.
Oh, good.
AKA the Cat Lady, thank you for the $2, guys. We need to get Runkle to translate this. Yes, or Omar, who I invited him, but he's doing some family stuff right now, so we'll see if he gets to join us in a little bit.
Lame. Just kidding.
Whoa.
Yeah, the interesting thing with them will be to see if they can look at some of this cited case law and give their opinion on relevance.
Okay. Where I keep losing my place. The opening brief freely admits that Rule 26's safe harbor applies only to the conduct that allegedly violated that rule. Read that. For that reason, Rule 26's safe harbor must be construed as not only shielding litigants from punishment under Rule 26, but also from punishment under any authority to the extent the punishment is based on the same conduct that allegedly violated Rule 26. Issues 1, 3, 4, and 5 all rest on the same mistaken assignment of error, and they all must fail for the same reason. The court did not err by denying Laura's motions to dismiss and acted within its authority to award Clayton attorney's fees under Title 25 statutes. Moreover, Laura has not
an athlete.
Oh my god. Moreover, Laura has not proven reversible error in the form of misconduct by the trial judge as alleged under Issue 2. Clayton contests the sufficiency of the evidence Laura presents to establish such error occurred. Even if those facts are accepted as both true and sufficient, the standard in Title 25, not Title 9, cases is harmless error, not structural error. An erroneous finding regarding a collateral fact used only for impeachment is harmless given the overall weight of the evidence in this case. For these reasons, the court should affirm. Okay. Hey, Rob, thank you for the 5. Hey, Lauren. Hello cannot be trusted. Once a liar on the stand, always a liar. It's very hard to believe in someone once they feel it's okay to lie. That's true. That's true.
Agreed.
Thank you, Rob. All right.
Hard to have trust.
Issue 1, the court did not sanction Laura under Rule 26 and did not err by awarding Clayton attorney's fees under other authorities. A standard of review. Generally, an award of sanctions is reviewed for abuse of discretion. Lund v. Donahoe. Okay. The court did not sanction Laura under Rule 26. The first threshold of this argument is whether the trial court sanctioned Laura under Rule 26 at all. To even consider Laura's argument, which she repeatedly asserts disposes of the entire case on appeal, this court must first entertain a most meaningless hypothetical. What if the trial court sanctioned Laura under Rule 26 and no other authority? Although Clayton moved for Rule 26 sanctions based on Laura's court filings relatively early in the case, he withdrew the motion on April 3rd with no objection by Laura and proceeded with other claims for relief under ARS 25-324, 25-415, and 25-809G. Okay. By the time of trial in June, there had not been a pending Rule 26 motion for over 2 months. Okay.
Yeah, so you can't say, hey, there was this sanction under Rule 26, they got rid of it and tried to get the sanction under something else, because there never was a sanction under 26.
Mm-hmm.
Right. Okay. After Clayton withdrew the motion, Laura argued in multiple filings and at trial that the court could not award sanctions under Rule 26. Laura filed her first motion to dismiss after Clayton answered the suit, but before the motion for Rule 26 sanctions. Okay. By the time of her second motion to dismiss, Clayton had already withdrawn the motion a month earlier, largely to avoid unnecessary satellite litigation Laura threatened to bring over the safe harbor issue. Oh, God. She raised her arguments over Rule 26 again in her pretrial statement and at trial. The court included detailed findings about the Rule 26 issue in the UAR, but the court ultimately only awarded attorneys' fees and costs under Title 25 statutes based on relative financial positions, unreasonable positions, and discovery and disclosure violations. The trial court did not rely on Rule 26 at all, despite Laura making it the centerpiece of her position in the proceeding. Therefore, to the extent Laura argues Rule 26 controls the outcome, the issue is simply moot. The parties can debate various sub-issues, whether RFL 26, ARCP 11, and FRCP 11 have identical requirements and / are governed by the same law, whether Clayton complied with Rule 26, whether Rule 26 requires strict compliance, whether non-compliance precludes an award sua sponte, whether a remedial award of attorney's fees and costs even qualifies as a sanction, and so on. But the inconvenient truth is that none of these questions are actually before this court.
Oh, dear.
Look at your super chat.
Oh, sorry. My bad. Caitlin Boyd, thank you for the 5. Waiting to go into labor with my real baby at the moment. Oh my gosh. Thanks for keeping me occupied.
Good luck, Caitlin.
Yeah, Caitlin, thank you so much for joining us. Good luck with that. Oh, man. Well, thanks for watching. As long as you can. Yeah. No, for sure. For sure. That honestly sounds very painful. So we wish you the best for sure.
It is.
It'll be smooth.
It's just like the worst pain of your life.
Yeah.
It'll be great.
No, but it's great. Yeah, it's all worth it. Only one of us has been there, so listen to her. Laura's reliance
advocate for yourself.
Oh, go ahead.
Make sure no matter what the doctors or the nurses say, advocate for yourself. Or if your partner's there, have them do it.
Since we're talking about the fake pregnancy, what do you mean by that?
They will try to do things that you don't want them to do.
Oh God, like what?
So I mean, like an epidural, for example, sometimes they'll push you for that. Like medicine on the baby's eyes when the baby's being born. If you're in pain and they're not listening to that or not helping you move around or whatever, it's just like, it's a lot of little things that can happen in there. You can go in with a birth plan, just like a page that has bullet points of like, these are the things I want or don't want to have happen, or an episiotomy if you don't want to have that.
Please tell me what that is.
It's where they cut the skin on the outside of your vagina open so the baby can come out. But if sometimes if you don't get that done though, it can tear, and sometimes the natural tear is actually worse than the cut. And it can actually tear all the way to your anus.
Jesus.
Yeah, you don't want that.
You don't want that. So
I
had to have an episiotomy, and I asked how many stitches, and they said, well, you can only see one.
Every freaking time, I swear, I talk to one of you, it's like I'm changing my mind about something significant.
Yeah,
it's gonna be great.
It's a lot. But yeah, I mean, like it happens, and then you have your baby there, and your mind is more on the baby than it is what you just went through.
I like the idea of having a plan. I recommend using PowerPoint.
Brooke J, thank you for the 5. Wait, I missed something. Are you grocery shopping while reading this at the same time? Please only do shots of something not gross. No, I'm definitely not grocery shopping, but the only thing I have in this hotel room is something gross. So
what's gross? Like what?
Toilet water?
Bad vodka. All right. Hey Rob, thank you for the 5. Quick question: is it possible she has the mind of a 14-year-old? I have a feeling that they are possibly money laundering using GoFundMe. I mean, maybe. Ron may not know anything. I have no idea. I mean, we can only speculate, right? So, but
It's a lot
there's,
of I think the speculation just reinforces that there's very little transparency in that whole
oh, that's
thing.
definitely true. Yeah.
And that's
And
the fundamental
and
issue,
trust in
right?
the family.
Yeah.
Jan has lied.
There's low trust and there's no transparency. And that's where we are. And we just have to go from there.
And Ron has lied too. He lied to Mike Marraccini.
Oh,
And
boy.
Oh
who knows
God.
who else he
Yeah.
lied to.
Why does my
That's so
exposure
terrible.
keep going up and down? What's happening here?
Oh man. All right. Anyways, now that we're past that whole stuff that you just taught me about that I really wish I had now.
Yeah, sorry.
Okay. Laura's reliance on her interpretation is misplaced. Like every other Title 25 litigant, knew she may be ordered to pay Clayton's attorney's fees when she filed the petition. Received notice again when he requested fees in his response under ARS 25-809G, and was reminded in nearly every subsequent filing and hearing thereafter. Even if Clayton never mentioned Rule 26 whatsoever, statutory remedies were always available.
Mm-hmm.
Laura asked this court to award her carte blanche because of a Rule 26 motion having once been filed. Her reading of Rule 26 would turn the safe harbor into a formalistic sinkhole and do damage to the statutory attorney's fees scheme. It has nothing to do with signing of filings.
Formalistic sinkhole. I'm putting that on my LinkedIn bio.
That's like a Black Widow, you know.
I know.
If you get to page 26,
Man-eater.
that's the Voldemort.
Julia,
Boy.
what's up? I haven't seen you in a second, have I? What is ROA, guys? ROA. What's the context?
I don't know what the context is, but I think it's well, maybe I do. I don't know what it stands for, but it's case documents that it's referencing. And I think in the digital copy there are like links, right, to like all of like the
yeah, this thing says Register of Actions.
Register of Actions.
Yeah.
That sounds right.
All right. Okay.
Record of action, yeah.
Did we start reading this paragraph yet? I keep getting lost. Rule 26 does not apply to awards given under ARS 25-324, blah, blah, blah.
Very good.
Laura argues that failure to strictly comply with Rule 26 precludes sanctions under any other authority. On its face, nothing in Rule 26 references any of the statutes permitting the court. I have the hiccups. Oh my God. I'm going to try to suppress that.
What is going on over there?
What's going on is I'm very tired. All right. Any of the statutes permitting the court to award attorney's fees and costs in Title 25. Award of attorney's fees after considering financial positions and reasonableness. ARS 25-415, award for false claims or disclosure/discovery violation. Well, we have that one for sure. ARS 25-809G, functionally identical to 25-324 in paternity proceedings not involving legal decision-making /parenting time /child support statutes. Laura relies mostly on case law interpreting the federal civil rules, the idea that sanctions are not available without invoking Rule 26, but this reading would expand the rule's scope far beyond its language, purpose, and common sense interpretation. To be clear, Rule 26 and its civil corollary ARCP 11 applies only to the signing of documents filed with the court. See 26. By signing a document and filing it with the court, the signer certifies that they have conducted a reasonable inquiry and believe the filing is for a proper purpose, warranted by law and supported by facts. 26. If the document is signed in violation of those requirements, the court may impose a sanction. 26. The remainder of the rule describes the procedure for requesting sanctions under this rule. Before filing a motion for sanctions under this rule, the moving party must blah, 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 I guess. Rule 26 says nothing about the myriad factors courts consider in whether to award fees in family law actions, including financial resources of the parties, reasonableness of positions, discovery and disclosure misconduct, or any other substantive basis for fees awards outside of the signing of a document. Sounds about right to me. Laura's argument seems to assume that Rule 26 is the exclusive vehicle to request an award of attorney's fees and costs, but there is no authority supporting this interminably broad limitation on the family court's remedial authority. The court's authority to award fees in other civil actions is far narrower, mostly relying on ARS 12-349, except in certain actions with specific fees statutes, for example, contract disputes. Of relevance here, ARCP 11's safe harbor provision is also codified in statute. See ARS 12-349C. Attorney's fees shall not be assessed if offending party voluntarily dismisses within a reasonable time after learning a claim is unjustified. There is no counterpart to this provision in Title 25. The court must also consider the practical implications of Laura's argument. And he's talking about another case here. See Hustralid v. Steak Bake? Steak Bake, what a name. Steak
Ooh.
Bake. I'm a fan. I like
Steak
that.
and bake.
Okay. When language is ambiguous, consider effects and consequences of differing interpretations. Laura's argument declares that Rule 26, once invoked, affords a party an absolute right to withdraw from litigation with no consequences. That is just ridiculous to me. Like, you could do anything, basically, just to punish someone. So, I don't know.
Psych, my bad.
Yeah, right. All right. And then they're citing Barber v. Miller. It must logically follow, then, that the safe harbor opportunity only comes into existence if a party or the court notifies the offender of their intent to seek Rule 26 sanctions. What does OB mean again? OB 111424? EP 38? I don't know.
This may just be another reference to material we have later, or an
I'm
index.
not the most smartest person at reading this stuff, guys. I'm just a cat.
Right?
AKA the cat lady. Is Lauren's voice getting lower and lower? Lauren's voice is getting tireder and tireder.
Mhm.
All right. Let's see. Arguing sua sponte sanctions cannot be imposed without a show cause order triggering safe harbor. She further asserts that other laws allowing sanctions no longer apply after a party claims a specific act violated Rule 26, i.e. the act of invoking Rule 26 or alleging a Rule 26 violation makes the rule the exclusive remedy for that conduct. All right. Assuming arguendo that these assertions are true as to sanctions under Rule 26, Laura asked this court to craft a safe harbor as to all forms of attorney's fees awards, notwithstanding their basis in law. Even the federal courts relying squarely on FRCP 11 do not go this far. See Marraccini v. Nation Star Mortgage. Okay, I won't do that, but okay. Even if safe harbor not given, court could still have imposed sanctions under Rule 11C3 statute or inherent powers. Matsumaru v. Sato 521. This is where it gets like a lot of legal jargon. I feel like.
Yes, this whole thing until like basically like page 50.
We'll skim through it, I guess. Plaintiff will have opportunity to persuade the court that sanctions should not be imposed under other authorities. This argument, if accepted, would assign a talismanic quality to Rule 26. Under Laura's interpretation, the offending filer would have an unconditional right to opt out of the litigation no matter how egregious their conduct or unreasonable their positions if the impotent invokes the rule.
Yeah.
However, if a party never invokes Rule 26, instead pleading a request for attorney's fees under ARS 25-324 or other applicable statutes, then the safe harbor opportunity would never materialize. Okay. In the surpassing majority of Title 25 cases, that is exactly what happens. A party reserves the right to request fees under ARS 25-324 /ARS 25-809G in their responsive pleading and never mentions Rule 26. Rule 26 demands are comparatively rare, as they should be given the narrow scope of the rule, and the court has never interpreted that rule as a necessary or exclusive mechanism for seeking fees in Title 25 cases. If the court adopts this interpretation, then the phrase Rule 26 will become the family law equivalent of Beetlejuice or Voldemort.
Oh,
they
boy.
did use Voldemort. Or what does this mean? Nigh.
So you should just quickly Google the Knights of Knee from Monty Python and just watch the first like 10 or 15 seconds of the video.
It'll get you demonetized, but
I mean, I'm just gonna watch it right now. Hang on.
Didn't think about that.
I mean, this is very interesting because he's sort of saying like the second you bring
I know
this
the rest
up.
of you can't see this, but what the hell is this?
Have you never seen Monty Python, the Holy Grail? Come on, Lauren. We have a lot of work to do. I like this argument. I mean,
All right, I've seen enough.
I understand his argument. He's basically saying nobody's ever going to touch this thing if this is the literal consequence of even mentioning it, let alone like they never had their motion ruled on. Their motion was not ruled on and granted,
Right.
which is what he's saying would have triggered the inability to do things under other sanctions. But they just mentioned it and then withdrew it.
Stephanie B, thank you for the 5. 3 more to go. Let's go. Thank you, Lauren, for reading this on your vacay. Thank you, Stephanie, for 5 very much. I appreciate it.
It is interesting. It'll be interesting to see, because I think this is the fundamental crux that they're going to be arguing about here. And it'll be interesting to see what the appellate court says about it.
Yeah. All right. Let's see. I got distracted by the Knights i.e. words with magical and counterintuitive effects triggered by their mere utterance.
Yeah.
Invoking Rule 26 would have so little value and so much risk that aggrieved parties would never use it again.
Correct.
Arizona law has disfavored magic words and exalting form over function, particularly when prioritizing formality would undercut the court's jurisdiction in a family law matter. Duckstein v. Wolf, interpreting Rule 31, former version of Rule 26, verification requirement as merely procedural, not jurisdictional, when a party violated the rule in a custody case. See also, oh god, not this again. 31. This is like where I'm going to skim a little bit. If Omar was here, I would let him drone on about that. But
yeah, this is all like case, as you can see.
Yeah, he's going through prior cases here.
Okay, well, we won't deal with that too much then. I'll leave that to the lawyers. But okay, all right. Let's skip down to here. Laura had notice and an opportunity to be heard, but she wanted notice and an opportunity to unconditionally withdraw after she initiated litigation and publicly alleged paternity.
That's the problem.
Oh god, here we go. Clayton testified that Laura contacted his family, acquaintances, employers, national media, and tabloids like The Sun, calling him a deadbeat.
Oh no.
Oh my god. The trial court has... What's that?
I said defamation case, anyone?
You're right. Well, she's going to try to sue everyone for defamation if she gets this overturned, I guess. Isn't that what was said earlier? Like, he hopes they get the thing overturned so she can sue everyone? Some shit like that. Like, how do you think that's going to go? Because, like, you have to do discovery and all that.
I mean, why does the result of this appeal matter for whether you would want to sue someone for defamation or not?
I don't know. They I guess they're implying that, like, so we've been saying definitively that she faked the pregnancy based on the court ruling and all the evidence and stuff like that. So I guess if it's overturned, she'll claim that it was like there was no finding that she faked a pregnancy, and so we're defaming her. I guess is what that's my takeaway.
I mean, there was a finding, and then the finding was overturned at a later date, and in that time, you could say, "Hey, I agree with this finding," even if it's overturned. I don't know. It doesn't make any sense to me.
So it should be
you have to prove somebody lied for defamation, at least for public figures. And you could do that regardless of the outcome of a appeal. Of course, it's very hard to do that. It's hard to prove somebody knew the correct answer and said the wrong answer on purpose in order to cost you money. Tough.
All right. Let's see. Trial court has broad discretion to deny a motion to withdraw a pleading and must award reasonable costs and attorney's fees if it determines a party filed a petition not grounded in fact. Well, that's definitely not the case here, is it? Okay, there's another case here.
Another interesting case there.
Let's see. I'm going to skip through some of this.
There's a lot of them here.
Yeah. Rule 11 case law does not foreclose the court's ability to sanction on its own motion. Okay. Even if the trial court had sanctioned Laura only through Rule 26, a counterfactual hypothetical, it still would not have erred. Laura relies primarily on Federal Rule 11 case law. It's true that Arizona's civil rules are modeled on the federal rules of civil procedure, and the family law rules were modeled on the state's civil rules, but there are numerous important differences in the present language. Accordingly, the ARCPs only apply when expressly incorporated into the family law rules, and case law interpreting the civil rules applies only when the language of the rule is substantially the same. Okay. Right. Turning to the question of whether the court may sanction a party on its own motion under Rule 26, Laura relies on the 1993 Advisory Committee notes to FRCP 11. She admits that the court can sanction a party on its own, but she asserts that requires a show cause order issued before voluntary dismissal or agreement to settle. So, does anybody know what a show cause order is? Because I actually don't. So, okay.
Before voluntary
it says a-
dismissal or agreement to settle.
It says it's an order that requires a party to explain why the court should or should not grant a request.
Give me 1 second. What's so funny?
You were just so distant all of a sudden.
Yeah, I had to
More specific filings required.
I had to walk over there to get something. My bad.
Did you hear it?
Yes, I did.
Okay, good.
Did I hear it? Yes. Did I take it in? No. Honestly, no.
Show cause order.
Right. Sorry, I'm trying to order food right now, guys. Because if I don't order before 11, which is in 27 minutes, I can't get it.
Oh yeah.
So
Get it.
Get that room service.
It's like, what's a show cause order? God, I want food. All right. Good here. Okay. Turning to the question, okay, blah, blah, blah. We're just gonna move on here because I'm dying. I need Omar.
I think his point is that as you go from federal to state to family court, the language becomes less and less restrictive on the procedural rules of what you have to do here.
Yes, and that's correct, and he goes into that, and he basically says that the court is like full of intelligent people, and if they wanted them to all say the same thing, then they would have made them all say the same thing.
Yeah.
And he says that Laura changes the language to suit whatever is best for her.
Yeah, that makes sense.
Or is picking and choosing, I suppose. Picking and choosing, probably. Yeah.
Yeah, I can't remember the exact wording that he used.
Okay.
All right. Let's see.
And I don't remember.
Rule 11. We're going to skip through some of this.
There's something up there that said Laura had, right there, Laura received ample notice.
The court was considering sanctioning her in a full evidentiary hearing to explain her position. If anything, Laura received more process than even the federal rule requires for a sua sponte sanction. Okay.
Oh, dear. Yeah, I mean, they lengthened the time of the hearing. You know, there were filings that go back to when Clayton was pro se talking about asking for sanctions.
Yep.
All right. As to whether the court can sanction under other authority after finding non-compliance with Rule 11, the case law is similarly unavailing. In Holgate v. Baldwin, I know I've heard that before. For example, the court said it could not sanction using its inherent or statutory power because that would require a finding of bad faith that was not made below, not because it lacked authority. Okay. We're going to skip through this. Okay. All right.
So Laura's argument right there, yeah.
Laura's arguments from Radcliffe arise from the same incorrect premise that the federal, state, civil, and family rules are substantively, I can speak, I swear, identical. Radcliffe says that servants,
I can speak. The servants' requirements.
The service requirements in FRCP is mandatory to trigger the safe harbor period. Servants requirement. I need help.
Drink.
I do not need to drink. I need I'm trying to this fucking thing is bothering me. Sorry. For some reason, it thinks my room number is wrong. I'm just like, no, please just bring me my steak at 11 p.m.
Oh yeah.
All right, where should I skip to here? Let's see.
There. Laura even goes as far as to replace
Mm.
terminology.
Okay. Can I get you to read from here to like down here, and I'll be done with what I'm saying?
Do you want to read
From
first?
just this paragraph? Yeah.
Yeah, I can read it.
Nice.
One of you, yeah.
Let's see. Actually, can you give me the sentence above it? What's the context?
Yes. 1 second. Let me see if I
Oh yeah. So to support her assertion that
Oh, sorry. My bad. There we
Article
go.
26 and FRCP 11 have identical requirements. So one is RFOP is the family law and FRCP is the federal, have identical requirements. Laura even goes so far as to replace the terminology used in that opinion where the different requirements of the rules are not helpful to her. Oh dear. Compare Radcliffe at 789 with, and there's a reference, replacing, quote, strict requirement that a motion be served with strict requirement that a written notice be served. Plus, even if the court had sanctioned Laura under Rule 26, and even if Laura was entitled to a written notice of the offending conduct 10 days before the motion, she received both on December 12th, 2023, more than 10 days before her motion to dismiss, and in Clayton's initial response. That's what we mentioned before. Non-exhaustive list of alleged Rule 26 violations in Clayton motion to amend. Okay, and there's
That's what that
another reference
ROA
there.
33
ROA.
thing is. Yeah.
Yeah, we got 33, ROA 9, episode 10. It's probably not episode. I don't know what it is.
I don't know.
The state rules also make no distinction, despite Laura's arguments otherwise, between the remedies available for sanctions imposed by motion versus those imposed by the court on its own initiative. Ooh, okay. Where's Lauren?
I'm here. I'm here.
We got to scroll.
I'm right here. Oh, you need to scroll. Hang on. Okay. Next, to the extent Laura argues more good faith consultation was required.
Well, I think it was it? Oh, yeah. That's where we are. Do you want me to keep reading or are you good?
Oh, you finish the page, yeah. Go ahead.
Next, to the extent Laura argues more good faith consultation was required, she once again ignores the case history and language of the rule itself. See, RFOP 9, parties not required to personally meet or contact each other if there is a current order prohibiting contact and the alleged victim is self-represented. Laura had an order of protection against Clayton. She was self-represented in this case at the time of the notice, and the motion for sanctions still attached a certificate explaining the efforts to resolve the offending conduct up to that point. Moreover, good faith consultation is a procedural requirement, not a jurisdictional one, and therefore may not be the basis for reversal after final judgment. Ooh. See, in remarriage of Dorman, 189 Arizona. Oh, that could be an interesting case. Okay. Discussing limitations on procedural challenges after the trial has occurred. Okay. Laura's remaining argument is that the purpose of the rule is the same, so their interpretation must be the same. If the Arizona Supreme Court intended to make the federal, state, civil, and family rules perfectly identical, it certainly knew how to do that, right? Like if they're different for a reason. This court must begin from the presumption that the drafters of the rules meant to change their terminology, and the words used in the rules mean what they say. Very good. See, for example, City of Surprise versus Arizona Corpcom. Oh, weird. Applying expressio unius to find legislature intentionally included and excluded terms in a statute. Oh boy. This is too much Latin for me. I just know Sabrina Carpenter's espresso. Okay. Even so, Laura did have opportunities to withdraw her petition before and after Clayton's response. She could have withdrawn the petition anytime before the response under Rule 46, and even after the court denied her first motion to dismiss. Laura declined to sign an affidavit that she was never pregnant by Clayton in exchange for dismissal with prejudice. Ooh, that's right. Remember that one? They tried. They tried to get her to do that. Okay.
Nick O'Brien, thank you for the 5. Have we not gotten 10 yet? No, that was 9. Thank you for number 9.
Oh dear.
All right,
Okay.
where are we at?
Here we go. In summary, The trial court did not sanction Laura under Rule 26, so there is no issue here for the court to properly consider. Even so, Laura misstates the federal interpretation of Rule 11 and ignores substantial differences in the Arizona rules. She also fails to account for the opportunities she had to avoid the outcome she now challenges. There is simply no error here. Bam, end of section.
That's a good one.
Okay, let's see. Issue 2, Laura has not shown prejudicial error by judicial misconduct. A standard of review. The controlling standard for alleged mistakes in family law proceedings is harmless error. Let's see. No cause shall be reserved for technical error in pleadings or proceedings when, upon the whole case, it shall appear that substantial justice has been done. Erfulp 86. At every stage of the proceeding, the court must disregard all errors and defects that do not affect any party's substantial rights. Generally, the appellate court affirms absent a clear abuse or legal error and resulting prejudice. Davis v. Davis. Okay. Wait, emphasis added and citation omitted. What does that mean?
I'm not sure. I mean, certainly he underlined the part and resulting prejudice. He has a citation here. I'm not sure what other citation he's omitting.
Yeah. Nick O'Brien, thank you for $5. The 10th one. He says drink. Okay, I guess I kind of have to now.
I'm gonna run and get one too.
Yeah, do it. We'll wait for you. Go ahead. I'll read while you're gone. Let's see. Counsel cannot find any example of Arizona courts applying structural error analysis in a family law case. The structural error doctrine is a creature of constitutional criminal law jurisprudence. A few cases support the use of a fundamental error standard in civil cases, which differs from structural error in that the complaint must still demonstrate prejudice. All right, there's some case law cited here. Laura cites unpublished cases from Kansas.
Oh dear.
Right there. Laura cites unpublished cases from Kansas, but they too espouse a harmless error review that is nearly identical to Arizona's approach. In summary, if a judgment can be sustained by substantial evidence apart from the challenged finding, it must be affirmed. Black v. Black, affirming judgment despite trial court basing its findings in part on undisclosed interview of children in custody case.
Ooh.
Well, there's no children in this case, so I don't know.
Well, it's a procedural thing.
Yeah, I got you. All right. B, Laura has not proven judicial misconduct. You mean a random accusation against her father is not proven judicial misconduct? Oh, man.
Oh, dear. This could be interesting.
Yeah. Oh, my gosh. Sunshine, thank you for the 5. Just to be sure, have a drink on me. It's my birthday. Happy birthday, Sunshine.
Yeah.
That's
Have
awesome.
a good one.
Henrietta says, your counter is broken. Is my counter broken? Yeah, it is broken, but I know it's been 10 at least. It's been 11, I think.
I see 11 starred messages, so.
Yeah, we're good. We're good. I don't know why it's doing that, but thank you, Sunshine. Okay. We're waiting for Schnitzel Ninja before I can take the shot of something disgusting. All right.
Oh, dear.
Laura uses structural error analysis for one obvious reason. It is the only standard that could result in reversal without demonstrating prejudicial effect.
Got it. Sorry, that took so long.
Prejudicial. Oh, you got it. Okay.
Yeah, it's on a whole different floor, so it took me a while.
Well, Jesus. Sorry, you're in the penthouse. My bad.
I'm in the basement now.
All right. Well, like promised, I am in my hotel room looking like that. These are my pajamas. But here's something nasty. So.
Oh boy.
Did you get a haircut recently?
Yes, I did.
It looks really good.
Thank you. I needed it very badly because I was getting like a little tiny mullet back here, and I was like, that is not for me. Nick O'Brien and happy birthday, Sunshine. This is for you and everyone else who's super chatting.
Yeah.
All right.
What is that? Canada Dry.
No. This is just nasty vodka in here.
What do you mean nasty vodka? What brand is
nasty
this?
vodka? Svedka?
Svedka?
That's nasty to me.
Is it in a plastic bottle?
It was in a little airplane bottle. I had a couple.
Oh, the airplane vodka? Yeah, that may or may not be good.
Yeah, I'm always carrying around those little airplane things whenever I'm at events and stuff like that. I'm like, I'm not paying at the bar $20 for a drink when I could get like 4 or 5 airplane bottles and just be set for the weekend.
$20 cocktails? What? Oh
Yeah.
dear.
I went downstairs and the cocktails were $18. $18,
Really?
and they're disgusting. So I
Oh
was like, absolutely
no.
not. I don't think so. I'm not doing
That's
that.
trouble.
Yeah. Anyways, cheers.
Cheers. I have some Woodford. Bruce.
I have a large cup.
God, I hated Svedka when I was young. Now it's just torture. Nasty. Right.
Yeah, you and
flasks
Clayton could
seems
have
the way to
matching
go.
mullets.
Yeah.
Matching mullets. I don't think it would look as good on me.
Business in front, party in the back. Come on, Lauren.
Oh, yeah.
Party's going to bed. All right. Back on 1 sec. Okay. Because she cannot show prejudice, Laura asked this court to announce an extraordinary deviation from the harmless error standard in civil cases. Okay. Also, I said I was going to. Do. Hang on.
This is
Since we met the 10, I said I was going to do a 5, and I'll tell you a secret.
Yes.
Oh.
It'll be. I don't know if it's going to be a substantial secret. It might be just like something I would never admit to anybody, but I'm going to admit it to 400 or 500 of you who are watching.
The harmless secret standard of civil cases.
I mean, what I have in mind right now is like, I hope I think of something else because this is just bad. Like, it's just bad. And, like, if I say this, I can't take it back. So, all right.
We need a better secret. I don't know.
No, it's okay.
We need a harmless secret.
Let me. That's not a secret, Stephanie.
Ooh.
Did you ever steal anything when you were a kid?
No. I was always a pretty good kid. I never really did anything to get in trouble or anything like that.
It's like truth or dare.
I did little stuff. Like my idea of doing something wrong was like we weren't supposed to have our phones at school, so you weren't supposed to have your headphones in, and I would walk around with my headphones in sometimes and try not to get caught by the teachers. So like that was the worst I ever did. Yeah. All right. Let's keep reading
What
this.
a crime.
Dude, they like didn't bother me because when I was in high school, and I don't know, have any of you ever seen Primetime with Alex Stein?
Mm-mm.
Okay, well, Alex Stein, he has a YouTube channel. He does a show, and he actually had Josh Sider on the other day talking about stuff. And I knew this guy in high school, and I guess he's the producer for Alex Stein now. And so I left a comment about Josh being a grifter, and he like messaged me for the first time in forever. And I was like, Jimmy, I remember you. I was so weird, and you were so nice to me. Like I was a very weird kid.
What did he say?
Oh no, he had my bad. He had messaged me first, and so I responded, and I was like, "Yes, of course I remember you. I was so weird, and you were like one of the only people who were nice to me."
Oh, what did he say in response to that?
We talked for a while. I'm not sure.
Oh,
So
wow.
he actually did this thing where he went viral like a little while back because well, the first thing he did, he applied for the Bachelorette, and his video went viral, and then he and his now wife did this thing where they invited a bunch of celebrities to their wedding. And they made it a thing on TikTok. And so his name's Jimmy Von Thrawn. And so like some of them like sent gifts and shit like that. It was pretty cool. So I was like, I remember seeing that, but I was like, I didn't follow up on it. Did anyone actually show up? And he was like, yeah, people sent like stuff, like they sent gifts and stuff, like George W. Bush sent a gift. And,
What?
yeah, some people actually responded. So
Get a salad spinner from George Bush? What?
yeah, that's crazy. So they just like invited a bunch of random people on, and they were like on TikTok, and I guess that like garnered a lot of attention. So maybe I'll do that for my next birthday party, which is no one else is invited. But hey Tiffany, what's up? Thank you for the $5. I'm so behind, but it's just a flash one. Thank you, Tiffany. Appreciate it. All right. The opening brief alleges the trial judge performed a secret independent investigation into the facts, which included reviewing and adopting as fact statements posted on social media, aka your blog. Laura draws this conclusion from the erroneous finding that Dr. Deans testified that Planned Parenthood is not open on Sundays. There is no dispute that Dr. Deans did not make this statement during her testimony, although she discussed other aspects of Planned Parenthood procedures learned during her time as a medical director with the organization. Okay.
Right.
To be clear, Laura's statements and use of fabricated evidence made issue of the location and date of her purported Planned Parenthood visit long before trial. At her deposition on March 1st, she said the visit was July 7th, not this again, in Mission Viejo, but she later changed the date to July 2nd and the location to Costa Mesa or somewhere else, vaguely in Southern California, for her April affidavit. This prompted follow-up with Planned Parenthood and was discussed in pretrial disclosure findings. And then there was something acknowledging Planned Parenthood had no record of a July 7th or July 2nd visit. Shocking. Laura's affidavit stating she went to Planned Parenthood while traveling in Southern California on July 2nd. Okay. And I don't know what ROA 119 is, but referencing false statements to court revealed by Laura's deposition testimony. Ultimately, however, it was Laura's unfulfilled burden to disclose the details of the visit, including the date, location, outcome, and associated records. To explain the fact that none of the locations she previously disclosed, none of them, had any record of a visit, she testified at trial that she went to Los Angeles Planned Parenthood on July 2nd using a pseudonym. You have to provide identification, so that's not possible.
Yeah.
Dr. Deans credibly testified that Planned Parenthood did not permit patients to use pseudonyms. The court made several findings impeaching Laura's statements, including the closed on Sunday conclusion that, although apparently true, was not given in testimony. So I think that is like, I think I said this earlier, but if you go to like a practice like that, like an outpatient practice, and you're asking for something and you refuse to give them identification, they're not going to do it because like it's not worth their license. So like if something happens and you've given them like false ID or something like that, and they suddenly don't know anything about you or your previous medical records, your allergies, anything like that, like
a lot of liability.
License, yeah, it's a total liability. And so like in that situation, the closest thing to like actually caring for you they're going to do is probably send you to an ER because you're out of your mind and you can't remember who you are. So and the ER at that point would have a social worker come and make their best effort to identify you and help you find your relatives and shit like that. So like, there's just no way. There's no
now,
way
what if she went to all of these Planned Parenthoods and this is just like some sort of Marvel Cinematic Universe multiverse theory, and she went to each one in a different universe?
Yeah, I mean, there's a definite possibility that she, went into these places just so she could say, "Here I am on camera." You know what I mean? Mm-hmm. But they would, if that were true, they would have the records. Even under a pseudonym. If she used a pseudonym, she would say, "This is my name," and they would have the record. So,
fair.
All right. Ultimately, however, is Laura's unfulfilled burden. I think we got to that part. There we go. Laura argues, as she did below, that this assertion must have come from an internet search. She alleges that the trial judge went online and performed an undisclosed investigation into the facts, and she then tried to conceal that misconduct by falsely attributing the testimony to Dr. Deans, who said no such thing. Laura provides no support for the contention the trial judge had illicit intent to conceal misconduct, aside from pure speculation. Logically,
also, why would somebody like try to do a cover-up that's so obviously wrong? Like, it doesn't make any sense. Like,
stupid. Oh man. All right. Oh, Tiffany says she had to get all the Infinity Stones.
Yeah.
Right. Okay. Where did we get through? The court made several findings. Laura argues, as she did below, the assertion must have come from an internet search. She alleged that the trial judge went online and performed an undisclosed investigation into the facts, and she then tried to conceal that misconduct by falsely attributing the testimony to Dr. Deans, who said no such thing. Laura provides no support for the contention the trial judge had illicit intent to conceal misconduct, aside from pure speculation. Logically, had the trial judge intended to conceal anything, there would be no reason to include the close on Sunday finding at all. It was cumulative impeachment with no impact on the outcome of the case.
Yeah.
When Laura moved for change of judge, alleging bias under Rule 6.1, the presiding judge reviewed the record and summarized the harmlessness neatly. Regardless of the source of the wrongly attributed statement about the operating hours, Laura repeatedly lied about the date and location of the visit. Okay. Even if the court accepted Laura's trial testimony as true, that she went to Planned Parenthood on July 2nd and obtained an ultrasound, Laura had already admitted to altering that image and to providing Clayton a 7-year-old sonogram video of twins she obtained online months earlier, which is like even worse now that her lawyer has admitted she never got a sonogram or had a doctor tell her that she was having twins.
Yeah, and even if she went to this Planned Parenthood on July 2nd and obtained an ultrasound, the provider did not send that ultrasound to Clayton's lawyer, which is the only way I'm going to accept the evidence.
Right.
We got just wanted to give a quick shout out to my friend Yamaha Biker in here. I was unsubbed. Hate it when they do that. Yeah, YouTube unsubscribes everyone to like random people. Like I get unsubscribed from Dave sometimes. I'm like, I watch Dave's stuff probably more than I watch most people's stuff. So ridiculous. The same thing with Tug at one point. But, yeah. So anyways, thank you for joining us, Yamaha Biker. I was briefly with Shizzy Wiznut on one of his streams reading a deposition relating to the What the Hail stuff. I didn't really know what was going on, but I agreed to read some of it to like play a role. And Yamaha Biker, I think it was Yamaha Biker, was on there playing Professor Snape, basically.
Nice.
If my uvula is swollen and I have a craving for pickles, does that mean something? It means you're having twins via your tonsils. For this case. Anyways.
Tonsil twins isn't confirmed.
That's real tonsil twins, bro.
They're real.
Pickly.
It's twin abscesses, but it's twins. All right.
After you put the pickles on the bread, put mustard on both sides.
Okay, let's see. The UAR discusses innumerable problems in Laura's presentation that have nothing to do with the July 2nd visit, including her tampering with evidence and that it was profoundly obvious that counsel for the petitioner was attempting to coach her answers. Oh no, not this. On cross-examination. Therefore, the truth or falsehood of Laura's ever-changing account of the Planned Parenthood visit was cumulative impeachment, not a critical element of the case. So I have a question. In all these videos that he's done, has he ever addressed that Laura made the false statement about what is it called? Smile? On the ultrasound?
I think he's been like, she was honest and she came forward and admitted her misstatement.
He seems to not worry about dishonesty as long as you fess up to it later. Which, I mean, that's good if it's a kid who stole a candy bar or something, but like
not a grown-ass woman.
We're in a court case.
My personal speculation, obviously, is that he would be outraged if the roles were reversed and somebody else had lied about a document like that, like tampered with a document like that.
Yeah, I mean,
not only tampered with a medical record, but lied in a deposition. But he's like acting like it's no big deal here, which again is part of the reason why I think this just like all points to him being a controlling douche who only cares about himself. It's like he does so much work to dodge things that she's done in past cases and like other details of the case that were before his time. That like if he really wanted to, like he could continue to like avoid this, but he's just kind of like bulldozing on like it just doesn't matter.
Yep.
And he's not even pretending anymore.
Yeah, exactly. And he's saying that at the end of the day, for this appeal, it doesn't matter. All that matters is the procedure that wasn't followed, according to him.
Damn. Yeah.
Okay.
Right.
And I mean, that's fine in these court filings, but
Right.
If you're doing PR, you got to also worry about the court of public opinion.
Greg Angel, we love you too. Thank you very much. Oh, I just got an email about the convention tomorrow. There's a schedule change. Let me see what's going on here. A few changes for Saturday. Yeah, I am.
6 a.m. snowball fight.
Yeah, right. No, thank you. Oh my god, I would die. All right.
Pillow fight then?
My gosh. They changed the whole order of things. So I guess somebody couldn't make it because of flight. So I guess they're hoping that she'll make it later in the day. But that kind of switches things up for me because I was gonna sleep in and now I can't. But that's okay. We're gonna keep going anyways. It's all good.
No rest for the wicked.
It'll give me more time to sleep in the afternoon, I guess. I'm too young to be this tired, but it's fine.
More Red Bulls.
You're busy. You have a lot of things going on.
So busy. All right. Okay. Regardless of the source of the wrongly attributed statement about the operating hours, Laura repeatedly lied about the date and location of the visit. Even if the court accepted Laura's trial testimony as true that she went to Planned Parenthood on July 2nd and obtained an ultrasound, Laura had already admitted to altering that image and to providing Clayton a 7. Oh, we already read this because I'm reading 7-year-old sonogram. Sorry, guys. I have ADD brain, so it's like I'm losing my touch. All right.
I have to highlight what I'm reading so I don't lose it.
Yeah. Well, because I start having conversations and then I just forget where I was reading. Therefore, the truth or falsehood of Laura's ever-changing account of the Planned Parenthood visit was cumulative impeachment, not a critical element of the case. It is nowhere evident how this error materially affected the outcome unless the court presumes the entire proceedings were somehow compromised, a la structural error. On the contrary, this record is so inundated with Laura's false assertions, many of which she conceded at trial, that the Planned Parenthood Los Angeles is closed on Sundays finding changes nothing at all. This court need not speculate about the reason or source of the finding to determine it was harmless in view of the overall record. See, if the trial court conducted extrinsic investigation, the facts determined were subject to judicial notice and substantively harmless. Assuming arguendo that the trial judge looked up the operating hours of Planned Parenthood Los Angeles, Laura has not proven prejudice. Arizona's Evidence Rule 201b2 permits the court to take notice of any fact that is not subject to reasonable dispute and can be readily determined from sources whose accuracy cannot reasonably be questioned. Oh, okay. The court may take notice on its own at any stage of the proceeding and give a party the opportunity to be heard. Okay, so this is... I don't think I've heard this before. As many times as we've heard the judge, did something wrong, but like...
Pretty interesting. The rules of evidence. I don't think we've reviewed these. 201B2, 201C through E.
Do you want me to see if I can find it?
Yeah, do it.
What page is this?
Sorry, what?
What page is this, just out of curiosity?
Page 40.
Okay.
I'm going to keep reading while you look. Laura does not contest that July 2nd was a Sunday. Okay. She probably would, though. As the calendar shows, that day was in fact a Sunday. She also does not appear to contest the truth of the conclusion that Planned Parenthood Los Angeles, PPLA, closes on Sundays, although she contends the truth of the statement is irrelevant because it was not in evidence. The question then is whether the trial court could ascertain the fact via judicial notice. Okay. Well, so here's the thing again, like as far as this appeal goes, I don't know, like with the contention of the truth of the statement is if it's irrelevant because it wasn't in evidence. I don't know. That's for them to argue in court. But as far as the public opinion goes, and when her lawyer, decided to jump into PR, this is a huge deal, regardless of whether or not it's procedurally correct. Like,
I mean, to some extent. I mean, let's say they were open. I mean, then, well, okay, where is the medical provider that can provide that ultrasound?
Yeah.
And also, if you have a high-risk pregnancy, is one ultrasound, like, if we're just talking about public opinion, to me, like, you're never going to have a high-risk pregnancy and just go randomly one day decide to go to a place that you don't even live to get your one ultrasound. That's still super negligent.
Yeah. I don't know, man. I mean,
not just negligent, super negligent.
Super negligent.
I don't know why I said that.
But just, I guess for me, though, from like just an opinion standpoint, if I'm just like looking at this as an outsider, like if she's not even contesting the fact that they were closed on Sunday and that she's, like saying the truth is irrelevant, then as an outsider looking at this just from a public opinion perspective, I'm going to be like, that is a giant red flag. So yeah.
Oh yeah. I mean, it's like if you're driving through town and you see your kid at the restaurant, they're supposed to be home doing their homework. And when they get home, they're like, oh, I was over here doing my homework. And you're like, okay, you were at this restaurant. Like, yeah, it's totally catching them right in their goofy story.
Is there a page number you want me to skip to here?
Yeah, if you go to page 6.
Okay.
Sorry, I tried to copy the text and it just copied the whole paragraph again. Page 6. Are you? Let me see. You're up in there. Okay. Then if you go to B, so it's got stuff crossed out, and then there's A and B kinds of facts.
Okay.
That maybe, and then B2 can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned.
Okay. So these are the rules of evidence. Yeah.
Yeah.
Yeah. So if the judge went to, PlannedParenthood.com, like, who is somebody going to be like, oh, that whole webpage is wrong? Like,
Right. And then
no.
he's also going to quote in here, he's going to talk about a case in which someone, albeit it was a government website that they went to, but that they did go to a website and did not alert the parties, but that it was a non-issue in that case.
Yeah.
Okay.
It's very similar.
Yeah. All right. Let's see. We got that part down. The court may take notice on its own. Give the party opportunity to be heard. Didn't contest that.
We're on the next page, I think.
Okay, cool. All right. State v. Rogers, or is it Rohers? I don't know. Illustrates the broad scope of judicial notice in Arizona precedent. I'm just going to say Rogers. Concerned the inevitable discovery of evidence in a suppression hearing, the trial court found a piece of evidence would have been discovered in the defendant's car based on the police department's standard inventory search procedures. The problem was that those standard procedures were not in evidence. Okay. On review, the Court of Appeals took judicial notice of the Phoenix Police Department's operations order on the department's website to cure the deficiency in the trial record. The court used the procedural manual and affirmed based on the provisions therein. The Court of Appeals determined Rogers was not prejudiced because even though the procedures were not in evidence, the trial court correctly interpreted them. Okay. Rogers represents a few key points. 1, judicial notice may be taken of standard operating procedures not otherwise in evidence. 2, judicial notice may be taken at any stage of the proceeding, including for the first time on appeal. 3, even in a criminal case where constitutional protections are at their most robust, an argument for fundamental error stating the trial court relied on facts, not in evidence, must still establish prejudice. And 4, the appellate court can use judicial notice to cure a deficiency in the trial record if the underlying error did not cause prejudice.
Very good. I wonder what was in that guy's car.
Totally not weed. The facts of the instant case are not so different from Rogers, even if the trial court searched PPLA's website and misattributed the operating hours to Dr. Deans because of her other testimony about Planned Parenthood's procedures. That information would be just as capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned as the police procedural order. Moreover, the PPLA finding is nowhere near as central to the dispute as the order in Rogers, where the police department's policies were outcome determinative of the suppression issue. Next, Laura contends that a business's operating hours are categorically ineligible for judicial notice. For judicial notice based on ABA Formal Opinion 478. Ignoring that the opinion is not precedential, its footnote 9 and hypothetical number 1 distinguish between essential and background facts, the latter being properly subject to judicial notice from publicly available and reliable sources. All right. See Roe v. Gibson.
Interesting.
Yeah. In Roe v. Gibson, the restaurant hours hypothetical sets out a scenario in which a plaintiff sues for unpaid overtime hours, and the judge independently researches the restaurant's location because he believes it would only be open during limited hours. ABA Formal Opinion 478. Okay. The opinion stipulates that the noticed facts are key to whether the plaintiff could prevail on a claim of unpaid overtime, and therefore should have been the subject of adversarial inquiry. Okay. Resolving an essential element of a claim with ex parte investigation, particularly basing the decision on the restaurant's industrial area location instead of its posted hours, is a far cry from what Laura alleges occurred in this case. Again, the challenge finding in the instant case is not critical to the outcome and does not establish an essential element of any claim. Rather, it is just one piece of impeachment material among countless others. Moreover, there is Arizona precedent supporting courts taking judicial notice of information on websites, albeit government websites in these examples. And he's just citing some more case law there.
Hmm.
D, harmless error applies even if the trial court independently investigated and did not notify the parties. Even if the trial court investigated without notice to the parties, the standard of review is still harmless error. Black v. Black is extremely instructive here. In Black, the trial judge conducted an off-the-record interview with the parties' children without notice or agreement of the parties. Huh. Okay. The court found, based on the undisclosed interview, that both children wanted to live with their father and only visit their mother. On appeal, Mother argued the trial court erred by conducting the interview and that the judge could not be sustained absent the interview finding. Critically, the Supreme Court said, although we find no record of an interview and agree that it should only have been conducted pursuant to a stipulation between the parties, we believe that such error was harmless in this instance.
Hmm.
The court acknowledged that the parties should have been notified of the court's actions, but because there was substantial evidence supporting the judgment, apart from any consideration of the interview, the judgment must be affirmed.
Right. So they probably had a whole bunch of extra context in that case.
Mhm.
Yeah.
Yeah, seems like it.
Dave is in the chat.
Kind of like this one.
Dave! Hi, Dave. Are you still
Oh
snowing?
my god. When you said Dave, I thought Dave.
Oh,
And I was like, what?
No.
our Dave.
Good.
Dave says, hang on, I gotta go back to the chat. Hey, Lauren, I just realized I never responded to you. I'm snowed in the compound. It's okay. I saw your video earlier. And also, I landed and I was like, you missed this story because you weren't here earlier, but I packed warm clothes to change into after I got off the plane, but I actually forgot to put the clothes in my bag. So I was walking around with capris on, like basically shin shorts,
Oh
and they
my
were
God.
thin, and a t-shirt. So,
That
that was
sounds
so
terrible.
cold.
Yeah, Dave. 6 a.m. pajama snowball fight. Get ready.
Yes. Oh my goodness. If you guys show up, then yeah, we'll do that. All right. Okay. Did we start this paragraph yet? The relevance of this precedent?
Let's see. I think we're at the bottom.
The
new
bottom. Laura
paragraph,
also
the very
cites
bottom.
the,
Yeah.
this one cites State v. Anderson. Okay. Stating that this alleged error is one so severe as to create defects in the trial mechanism itself and affect the entire conduct of the trial from beginning to end, damaging the framework within which the trial proceeds. But she also explains that the error could have been made after trial because the issue of whether PPLA was open on July 2nd did not arise until Laura's thrice changed testimony. I don't know why that's so funny to me, but it is. Thrice changed testimony that day. If Laura is correct, the trial judge read her attorney's blog and made the finding based on what she saw there. And there was no defect at trial at all. That is, unless the court believes Laura's... Is it vacuous? How do you say that word? Vacuous?
Yep.
Claim that the judge manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings. But what about her father?
I don't think we've gotten there yet.
No. No, is he mentioned in here? I don't know.
I'm not sure.
He is not mentioned.
Well, he's irrelevant, so that's good.
I mean,
not relevant in general, just to this shit.
Right.
All right.
Yeah, losing a bunch of filings doesn't mean there's bias. It just means you're not doing a good job making those filings.
All right, let's see.
Or at least, how do I tell the difference? They haven't demonstrated how I would tell the difference in this case.
Yeah, that's just nutty. All right. Give me 1 second, guys. I'm trying to send something real quick. Dave, I'm sure you're with the baby, but if you're not, I'm sending you a message on Instagram with the link.
Come on.
There we go. Yeah, you can join us, but usually, like, he's at night, he's like got the baby on his shoulder or whatever. So, like, I don't know. I mean, yeah, I guess that's a good excuse. I don't know.
I guess you had to take care of a kid.
Yeah, the umpire is biased against me when I walk a batter. Yeah, pitch better.
All right. If Laura is correct that the trial judge read her attorney's blog and made the finding based on what she saw there, then there was no defect at trial at all. That is, unless the court believes Laura's vacuous claims of the judge manifested clear prejudice and or bias early in the proceedings in the form of multiple unexplained adverse rulings against her. All right. And then see this quoting Laura's notice of change for judge. And again, the impact of the finding is meaningless within the broader context of the judgment.
Right.
If there was ever a time for Arizona's highest court to deviate from the harmless error standard in family court case, it would have had every reason to do so in black to protect the fundamental liberty interest at stake. Santosky v. Kramer, parents have fundamental liberty interest in the case, custody, and management of their child. Yet the Supreme Court declined, and so should this court.
Yeah. I mean, in that case, had actual children. Imagine that.
Sorry, I'm responding to Dave here. Okay. Let's see. Invited error is not reversible on appeal. Perhaps lost in all this discussion is the underlying reason for the error, Laura alleges. Even a fundamental and prejudicial error does not win reversal if the complaining party was the source of the error. All right. There is no dispute whatsoever that Laura's misrepresentations are the reason this issue arose. The opening brief acknowledges, and the record proves, that Laura gave several different versions of her account of the Planned Parenthood visit before trial. She also admitted to altering the ultrasound image she initially claimed to have obtained at the July 7th visit. July 2nd, question mark.
I love
the Mission Viejo, Costa Mesa, question mark, Los Angeles, question mark.
Multiverses confirmed.
Oh my god. She claimed to have been using a pseudonym, but refused to disclose it. Yeah, so for real, she obviously knows the name that she used, so it'd be very obvious, even if that were real, it'd be very, very easy for her to tell them the name that she used and obtain the record. So it's just not.
If she literally did use a fake name to go get an ultrasound at Planned Parenthood, would that be like a criminal action? Or what? Like that's
okay,
weird.
Say that one more time. My bad.
If she literally, like, I don't know. I think a lot of people don't believe she actually ever went to one of these things.
And then also she had to pay. So did she pay with a credit card or did she pay with cash?
Yeah. If she actually did literally get an LA ultrasound on July 2nd with a fake name, is that like medical fraud? Like, is that some sort of crime? Like,
if she tried to present
a crime to me,
if she was like within her right mind and she presented it as a fact, knowing obviously that that's not her identity, and she presented like a fake identity, like ID or something, then yeah, probably. But like
not like a famous person who's like, hey, I'm Brad Pitt. I need to use a fake ID.
Right.
And they're like,
sure,
oh,
Brad
okay.
Pitt.
But
okay, Brad Pitt
she had a number one podcast 15 years ago, Bruce.
Oh my god.
David's too soon,
yeah,
Dave.
I know.
Dave says, let me be the first to state this. Laura is going to claim the PP surveillance footage burnt down in the fires. She's kicking herself for not choosing Pacific Palisades. Listen, that's awful, but also not entirely out of the question.
And also, that is PPPP. Just want to
this is too soon. It's not even a joke. It's not.
Dave is killing me right now.
Oh man. That's terrible, but yes, it's honestly like I wouldn't put it past her.
Do a poll if we think she thought of that.
Okay, will Laura claim her records burnt in the fire?
Oh no.
Did she think yesterday? Shit, I should have said it was Pacific Palisades.
Not a Q&A. I want a poll. Hang on. All right. Let's see.
I've been to Planned Parenthood and I had to show my license. Yeah. And I mean, they're not bouncers like checking for fake licenses or anything, but yeah, I mean, so much of this is just not really plausible.
Yeah, I mean, even if there was one ultrasound from Planned Parenthood for a supposed high-risk pregnancy, which itself is negligent, we still don't have paternity determination.
Right. And
exactly. What we're looking for here is a ruling of non-paternity.
Exactly.
Well, so far we have 100% yes on the poll.
Dave is so right. Oh my gosh.
Mhm.
Jesus. All right. Let's try to move on from that. Okay. She never disclosed information accurate enough to obtain any original records, resulting in substantial discovery efforts that were entirely wasted. Had Laura been honest, complied with her disclosure obligations, and not changed her testimony yet again at trial, there would be no reason for any of this inquiry. Moreover, Laura alleges one source for the errant finding, comments left on her attorney's blog about the case. And by the way, I forgot to say this when we were talking about that, but like, there's now, and I think in most states, a penalty if you don't have electronic medical records. So I'm pretty sure Planned Parenthood probably has, because they're a government, entity or whatever. I'm pretty sure they have electronic medical records. So
Oh,
even
yeah.
if she were to say this burned down in the fire,
Oh yeah, that
Right.
was actually when I was working as an intern for the Bureau of Healthcare Financing for the state of Wisconsin. I was working on a project where one of my jobs, there was a computer system and there were manuals for different things. And I had to go, they were transitioning the system. So I had to go around town to different offices to find people I had a list of all the manuals. I had to create 3 sets of these manuals, 3 full sets. It was like collecting Pokemon or something.
Well,
Because one was going to go to the new people taking over, and like 2 other ones were going to these separate record basements off site, because if the building burns down, they want other copies.
Mhm.
And that's exactly what they do. They do backups at different physical locations.
Yeah.
So that if there's a fire or an earthquake or a
Yep.
tornado, you don't lose your information.
Mhm. Mhm. And for some reason, this made me, well, I guess because we're talking about Planned Parenthood, I don't remember if I said this before, but one of the times when Mike took her to Planned Parenthood to get pills for an abortion, he said that she was in there for 5 minutes and came out and said she had taken them. I'm telling you, there's no fucking way in hell you go in and you get checked in and you get called back and read all the instructions on the pills and given the pills, take the pills, wait and make sure you don't have any reaction to said
Yeah.
pills, and then go out. No way that happens in anywhere near 5 minutes
Or even 10 minutes.
or even 10
Let's
minutes
double it.
or
Yeah.
even a half an hour. There's
Yeah,
no
right.
way.
Yeah, you're going to be in the waiting room for a while.
Yeah, and they make you wait around afterwards to make sure you don't have any adverse reactions.
Right.
Like, immediate, like an allergic reaction or something that's like an immediate thing.
Hmm. Hmm. Dave says she has the fast pass like at Disney World.
they give you a transponder. A transponder. Oh my gosh. All right. We got past here. I lost my place again. And Laura been honest. We read that. Moreover, Laura
Also, wait,
alleges-
sorry. She made him wait in the car. That was the other thing. She said, "No, you don't need to come in with me. I'll go in alone."
Okay, cool. I wonder
sus.
why. Sure. Okay.
Poor Jan.
Moreover, Laura alleges one source for the errant finding, comments left on her attorney's blog about the case. Lastly, this is not a case in which hardship to the appellee can be ignored. In structural error criminal cases, which she might have soon, the state is obligated to avoid errors and will not be prejudiced by reversal. It will simply conduct a new trial using its vast resources. In
Right.
civil cases, however, reversal in the face of harmless error would force the appellee back into litigation without good cause. In the instant case, Clayton did not ask the trial court to find PPLA as closed on Sundays.
Right.
He did not ask the court to conduct an independent investigation if that occurred. There is no plausible argument that the outcome would have been different but for the challenge finding. Preventing unnecessary retrial is both the essence and purpose of harmless error. The reviewing court should not waste judicial or party resources or police resources or anything else that may be called over irregularity when substantial justice has been done. Absent a finding that the record could not support the judgment, a finding that is impossible here, this court may simply affirm.
Yeah.
All right. We have issue 3. The trial court correctly awarded attorney's fees under ARS 25324, 25415, and 25809. For issue 3, Laura argues the court erred by relying on ARS 25-324, and ARS 25-415 as bases for the attorney's fees and cost award. These arguments are frivolous. Well, the whole thing's frivolous. Yeah, okay, sure. First, Laura argues ARS 25-324 only applies to the proceedings under Title 25, Chapters 3 and 4, whereas paternity proceedings arise exclusively from Chapter 6. She cites no authority supporting this limited interpretation, and counsel can find no example of a paternity opinion declining to consider ARS 25-324.
I think that's one of the points Omar pointed out maybe earlier.
Yeah. There's a footnote here that also says she also relies on the Rule 26 safe harbor argument raised in Issue 1, the response to which will not be repeated here. Clayton's responses in this section concern only the arguments relating to the applicability of ARS 25-324, 25-415, 25-809. All right, let's see. She cites no authority supporting this limited interpretation, and counsel can find no example of a paternity opinion declining to consider ARS 25-324. Paternity proceedings nearly always involve determining legal decision making. They almost always, nearly always involve babies, but and parenting time, which places them within the ambit of Chapter 4. Any party other than any party other than the state may request determination of legal decision making and parenting time as part of paternity proceeding. Paternity proceedings always require determination of child support, which places them within the ambit of Chapter 3. See ARS 25-809, requiring past and future support pursuant to ARS 25-320. Moreover, courts routinely apply ARS 25-324 in published paternity cases. Okay. The instant case is no different. Laura petitioned for findings of paternity and determination of legal decision-making, parenting time, and child support.
Yep.
Laura herself requested attorney's fees under ARS 25-324 during proceedings, including by motion and in her pretrial statement. Was that like when she was pro se, or was it after she got an attorney?
I think that's at the beginning.
Yeah, I thought it was. Yeah.
Yeah, I think that's the thing Omar was pointing out.
Yeah.
This section, yeah.
Okay. To raise this argument for the first time now, particularly after Laura tried to avail herself of the same remedy, is both nonsensical and impermissible. Our adversarial system properly and necessarily precludes injection of new issues on appeal. Huh. Okay. ARS 25-415. Next, Laura argues the trial court could not use... Well, you tell them. All right. The trial court cannot use ARS 25-415 as the basis for sanctions because the false claims provision of that statute does not apply in a simple paternity case. Is it simple if it's a immaculate pregnancy that did not result in the birth of a child? Okay. Clayton disputes the no false claims assertion for the reasons described herein, but it is also irrelevant because Laura definitely violated a court order compelling disclosure or discovery. Do you think she did that? The opening brief asserts there was literally no basis for the court to hold that Laura violated any order compelling discovery, but the court found Laura repeatedly violated Rule 49 even after being ordered to comply. Huh. That seems like
Gosh.
This is the one that he was saying today on the video that like it was so bizarre, the motion to compel and all this stuff, and that's not how it's supposed to go.
I'm sorry. What is the argument there? I don't understand. Like, why is that bizarre?
He didn't say what. I don't recall him saying what the procedure should be, but he was saying that in a family like a paternity case like this, you wouldn't file a motion to compel normally. Like, I don't believe him at all. But so he was saying that since Woodnick filed the motion to compel, it was very bizarre, and that basically Laura didn't have to comply because it was like uncalled for, basically.
K-Make Biz Runner, thank you for the 50. I appreciate that. Don't blame Baby Jingy. This was all before his time. I can't do it. Like saying like Baby Jingy to me is still like, I don't know what it is. It's like moist. It's like saying moist. I don't know why. Maybe it's because the diaper is moist. I don't know. It's just a thing for me. I'm just like, I can't say baby.
A baby's Jingy. Diaper?
Baby Jingy. That creeps me out, dude. It creeps me out. I can't help it.
Clean up in aisle 3 of Home Depot, I guess.
Clean up in all the aisles at Home Depot for this one, man. This guy's shitting everywhere. He's full of shit. He's unleashing all over the Home Depot.
It's diarrhea.
Baby Jingy is my greatest contribution to this mess. I can't do it. I know Dave does the like cry voice and everything. He goes all out, and I'm just like, I can't. It's like nails on a chalkboard, like moist in the pants. I can't do it.
Moist in the pants. Oh,
Moist in the pants. Be right back. Updating my LinkedIn profile.
Oh well, you're definitely not going to be fake retired for much longer then. Baby Jingy is my Mona Lisa. What is my Mona Lisa? Let me think about this. Do I have a Mona Lisa on this game?
Your cesspool is my jacuzzi.
That's just my general tagline.
But it's great.
Okay. Well, we'll think. I don't think I do, but if I think of something.
Gingerbread man?
Not the gingerbread man. Look at me, Daddy.
Say Baby Jingy is gingerbread man.
Oh no.
Baby Jing. I can't. I can't do it. I can't do it.
We're in danger.
Oh, my costume. Literally the Mona Lisa there.
Yeah,
like,
that is
there it
pretty good.
is.
The wig
That's
and
good.
the...
We'll take that. We'll take that.
That's great.
I'll take it. All right. Clayton disputes the no false claims assertion for the reasons described herein, but it is also irrelevant because Laura definitely violated a court order compelling disclosure discovery.
Definitely.
We read that. Yeah. The opening.
I mean,
brief
not only
asserts-
that one, but dodging a deposition as well.
Mhm.
So
She claims she was waiting for a ruling on, I think, for the case to be sealed or some. I can't remember what she said, but
Well,
some
you
ruling.
don't,
and
you
that's
don't
where
get
she
to
didn't
do
go.
that.
congrats.
Right? Right?
No, seriously. Oh man.
Excuses.
Let's see. The opening brief asserts there was literally no basis for the court to hold that Laura violated any order compelling discovery. That's hilarious. Compelling discovery. But the court. That's hilarious.
Pay no attention to the last year.
But the court found Laura repeatedly violated Rule 49 even after being ordered to comply. The opening brief concedes that there was also an order compelling disclosure, but asserts that Laura somehow fully complied with that order.
By
This is a
disclosing
comedy
all
script.
required information. Interesting.
Yeah, right. Disclosing all required information.
Yeah,
Yet
well,
everyone-
your phone was asked for and you didn't give over your phone, so
Mhm.
I wonder why.
Oh my god.
No. Weird definition of all, weird definition of required.
Weird definition of complied.
Yeah.
Oh my god. Yeah, everyone acknowledges her noncompliance. For example, Laura changed her story about the Planned Parenthood Mission Viejo visit on or about July 7th numerous times, even if there were no other examples. For example, Laura admitting she deliberately altered the evidence. The court may treat evasive or incomplete disclosure as failure to disclose. That is exactly what occurred here. While
I
she
was like,
failed to
mhm.
provide, is this
Evasive is being generous.
What is this quote from? Do we know?
It's a filing.
While she failed to provide records of any Planned Parenthood appointment, Clayton presumably sought records from all Mission Viejo Planned Parenthoods. Yep, as that is where up until today, Laura disclosed she sought care.
Oh, it's the
This is-
under advisement ruling by.
Oh, okay. This undoubtedly caused Clayton to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles. Well, now they got, destroyed in the fire, but now appear to have never existed in Mission Viejo. Additionally, Laura acknowledged she altered HCG test results, an ultrasound, and a sonogram.
It's a wild moose hunt.
My God. Laura's assertion that she fully complied with the disclosure order is simply not accurate. The trial court acted fully within the authority given under ARS 25415. So, question for Snitzel Ninja and or Bruce. So this right here, what was his kind of response to that? Did David say anything about that?
He was saying she didn't have to comply because of the bizarre.
What the fuck do you mean she didn't have to comply?
I would have to go back and watch exactly what he said, but his basic gist was that wasn't typical for like a paternity case, and so she did what she was supposed to do.
No, she didn't, because the judge tells you what you're supposed to do. I mean, what?
Right.
What? Jesus Christ. All right.
Very strange.
Mm-hmm.
Very, very strange.
I mean, they can argue, but
Yeah.
we'll see if it does any good.
ARS 25-809G and separate.
Omar asked, what did he miss? You missed the first 50 out of 63 pages, buddy.
I said everything.
Yeah, I sent you a link in your email if you want it, but I know you're busy with family stuff. All right. Next, she argues the court could not award attorney's fees because no motion was ever filed seeking sanctions under this again, ARS 25-415 or any of the other authorities cited in the trial court's June 17th ruling. In fact, the parties cited these authorities in filings throughout the matter. Okay, there's a response acknowledging both sides seek award and treating Laura's motion to dismiss as a request for attorney's fees. Okay. ROA 95, EP 14. Okay. All right. I'm going to skip over that little jargon stuff. Laura asked this court to declare fees can never be awarded unless a party files a separate motion requesting them. But the statutes do not even require a formal request from a party, let alone a separate motion. She frames the argument this way because a separate motion would be necessary to support her ubiquitous safe harbor interpretation, but there is no such requirement to be found in the statutes. Lastly, Laura concedes that ARS 25-809G applies to this class of proceedings, saying the correct statute does permit fees to be awarded where a party has engaged in unreasonable litigation conduct. Well, and such conduct necessarily caused the other party to incur fees and costs. So far, so good.
Yeah.
She argues the court could not give this award based on what? Again, like, what did you just say? Like, okay. She argues the court could not give this award, however, because Laura attempted to invoke safe harbor before most of the fees were incurred. Okay, of course she's going to be like JK before anything gets bad. In doing so, she imputes limitations on the statute that cannot be found in its text. The court may order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding.
Yeah, that's pretty important because a lot of the damage in the public eye was, I guess, it was already there before they enumerated all these fees, right?
Mhm.
Like the minute she went to the Sun and started arguing with people on Reddit and tried to get jobs canceled that Clayton had lined up, that was the damage. And the remedy for that is the ruling of non-paternity. And if the judge wants to award sanctions as you do that, they should be able to. Because the Clayton is just defending his paternity proceeding. And I mean, I'm just a layman, but like it makes sense to me. Okay. Like I'm not saying it's the right ruling or whatever, but it makes sense.
Okay. Let's see. The court may order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding. Nothing in the statute declares those fees must be incurred before a given date or case event, nor does it contain any safe harbor or other provision allowing a party to withdraw.
Omar says, let me in.
Oh, yes. Yo, what's up?
Yo, what's up, everybody?
How's it going?
Yeah.
Oh, I gotta stop doing my intro like that. My wife had comments.
Oh, no.
It's like, why do you sound like the Rolo
The
guy?
Knights of Knee.
You don't know about the Knights of Knee? What is this? What is
I do
this?
now. I mean, I didn't before.
We have a lot of work to do.
You need lots of work. Although that is an older reference, it's forgivable for a millennial.
Yeah.
Or not even a millennial. Are you millennial or Gen Z?
I was born in 92. I'm pretty sure I'm a millennial. Yeah.
I don't even know what that would be. Let's just say millennial for fun.
Okay. Sounds good.
Till 96. 81 to 96.
So y'all don't got to catch me up, man. I'm like coming in 2 hours and 15 minutes into the stream. I'm sure you guys have made a lot of
Hold on, the guys at my door.
I'm here for emotional support.
We need you to interpret a lot of the legalese above.
Oh, well, that's the easy part of it.
You're going to have to, well, some of the case references and whether they make sense or not. I think it's pretty typical, right? He goes through a quick synopsis of the, a recap, if you will. And then because the original appeal was 5 points, right? 5 main sections.
Mm.
He's just going through these 5 sections.
Yeah, that's all you do. He's just responding to
Yeah.
what Gingy had to say, and I had my ideas or predictions about how he was going to attack it.
Mm-hmm.
I'm more curious to see how far off the mark I was if he's attacking it the same way.
Well, the one specifically about family law and creating like a family plan or family time applying to the rules, which I think you had pointed out.
Yeah.
I think he spent some time talking about that. So I think you guys both caught that.
Well, yeah, there was that. But that was because Gingerbread over there was saying that somehow those rules didn't apply.
Right.
I didn't understand his logic in the moment. And then I pointed those things out and he called me a liar. And so I was like, well, let's just see what Woodnick has to say. I'm so curious.
Yeah.
Am I retarded? Am I missing? Oh, I'm sorry. I can't say that word. Am I being
Sanctions.
I don't know. What would be a good substitute for the R word?
Incompetent.
Incompetent.
In this
Am I
context,
being
in this
incompetent
context, because you're trying to analyze the legal
Yeah,
briefs.
and like, am I missing something? Like, how is it really that simple? Like, I felt like it was a simple argument to make, but I felt like it was also the obvious argument to make. I mean, she asked for a parenting plan, so
Yeah.
what is it with this chapter nonsense?
Right.
Why are we so focused on the Rule 26 stuff? I'm really curious. I'm going to spend some time reading this like on my own, and I'm going to go over it next week at some point. But I don't know. What do you think? Who's the winner? 50 pages in.
I think 100% Marcus, Team Woodnick.
Is the winner?
I do. I think it's written better, like much better. I think that it's more matter of fact and actually more legal in that sense, where her lawyer is always talking about procedure and stuff, and I think this is just covers that so
It's so funny. You guys were talking earlier, and then you made this like statement. Then Gingerbread over there said that you guys are mad at me because my arguments are just more technical. It's like, it's not that they're technical. The point is, whenever you're making legal arguments, the more technical you have to get, the greater chance you're on the losing side of the argument. Like, these legal arguments should be matter of fact. And if I just felt like it was pretty matter of factly wrong to suggest that somehow parenting plan sanctions didn't apply because of Rule 26. It doesn't make any logical sense. I talked to other lawyers about it. Lawyer's friend, what's his name? Patrick, I think.
Yes.
I had like a whole 30, 45-minute conversation about it. I was like asking him, am I really that incompetent? Not our word, incompetent, that I'm missing something obvious? Like, I was really self-conscious about it. Like, what am I? Yeah. Am I being obtuse?
Mistake. Yeah. Am I missing something simple?
Right. Because I put like a couple of videos out there going in depth about it. And,
well, so far as a layman, Marcus's arguments here make sense to me and I can understand them. And I think the nice thing he does is when he's referencing prior case law, he puts a very succinct summary of the attributes of those cases in parentheses after his citation.
Yes.
Which I think really helps.
Why it's pertinent to this case.
Well, Woodnick is the author of Rule 26 himself. And is Dave Neal giving Gingy sympathy points? I respect that.
He's team Gingy. And somebody said, what did Gingy say? He has 2 words he could reply with again. It was
so what?
So what? Yeah, basically, he doesn't care if she lied or not, which is just saying a lot about your character, man.
Gingy is my homeboy.
Gingerbread.
And he's
I'm not going to a strip club with you guys.
I'm not gonna trash up Lauren's stream again. I promise.
Marcus was talking about earlier how there are differences between like the civil and the family law, those 3 that he mentioned in federal. So to me, her lawyer is taking this on as more of a civil, like a criminal type case, not a family law case. and
Yeah, he is.
it has
Well, they're
stricter
cherry
rules.
picking what they want. Yeah.
Right. But it doesn't apply. It doesn't actually apply to this case. And
Well,
that's, for me, that's the biggest problem, is that he's trying to use rules from a different like court system and apply them here.
I'll tell you what, like the origin of his appeal, when I talked to him way back in, I don't even know, before he filed his appellate brief,
Yeah.
when he was working on it, he was throwing out this idea about Federal Rule 11, which you've heard him talk enough about, and how
Sure.
that's the same thing as Rule 26. And it has to apply here. And you're right, he was applying it in the civil context. But family law is just, it's so fluid. And there's like so many different ways to sanction things. And the problem with family law is it's not so cut and dry. We're not dealing with contracts. We're dealing with people's behavior. And you give these judges so much leeway and discretion when to authorize and sanction individuals for poor behavior that you think there's like a handful of rules. There's like an infinite number of ways that you could punish bad behavior. And you're not limited by the strictures of a Federal Rule 11 or Rule 26 in this case, especially when, the Judge Mata made the findings that she did. And they're all based on misrepresentations and lying on the stand and perjury and fraud and extortion, I think was got in there.
Yeah, that's in here too. That's explicitly part of this reply, is that the federal versus the state versus the family law in the state are worded differently. And if they're not worded differently, that's when the framers of these things wanted them to be treated the same. The different wording is there on purpose, and it has to be taken into account. And that's the argument here in this reply.
Well, I would agree with that. I mean, that would have been my simplistic view like a months ago when I was analyzing. Is like, okay, but what about, I even asked Gingras that. I remember having this conversation with him.
Mm-hmm.
What about the discretion of the judge to just sanction her anyway?
Yeah.
And it's like, no, you cannot do that, because Rule 11 is so important to the structure of American law. Like, okay, but it just feels like she can, if I read the plain language of the statutes. Yeah. And so I gave him benefit of the doubt. I read his motions. I read his appeal. I still came away with the same conclusion. And it looks like Woodnick is, I'm not going to say he's on the same track with me. I'm on the same track. He's aces on this case, man. He's taking the lead here. I just casually read and gave my opinions from California as an unqualified California family law attorney.
Yeah. There we go.
So there's that.
I've been in a whole different world over here.
What are you doing, Lauren? Did you get your room service yet? What is happening?
Did. So it got here. I let the guy give it to me. And then so they forgot to give me silverware because this was Uber Eats. So I started eating the steak with my hands while y'all were talking, right?
Oh,
and
then,
anyways, I got the sauce and I picked it up and then I dropped the sauce container. So all of a sudden there's sauce splattered all over the carpet of the hotel and on my foot. And so I'm like down on the ground scrubbing this out of the carpet while you guys are
God.
So there was so much happening over
Eating
here.
steak with your hands, not knowing Monty Python. We have so much work to do, guys. We have so much work.
Oh, we got to pull up that clip right now. We are the Knights.
well, she got demonetized for pulling up SpongeBob. So
you can.
She
You
I
got
want to
to
wreck
her
the
own.
stream.
Yeah, they're really strict with that. I don't know how these movie review YouTube channels exist. Every time I've played like even a 30-second clip, instantly copyright. Get rid of it right now, or we're not going to let you put it back. It's like, Jesus, okay.
Mm.
Pardon me for trying to bring some
Who's the one I get in my
levity.
feed? It's Amanda the Jedi, and she goes over like horror movies and superhero movies and stuff. And I don't know how she does it without
Maybe she gets prior permission or
getting
something.
stricken. Yeah, maybe.
I don't know, man. I don't know.
She has a
Maybe.
very big channel. It's like hundreds of thousands of subscribers. So I don't know.
Just
Oh,
like
I
their
don't know.
number one podcast.
Jeez,
Oh
why?
my god.
Why do I have to see this?
Oh my god.
Lauren
What
is
did
going
Lauren do?
feral down here. She's snowed in. She's got steak with her hands. She's got foot sauce.
Does she have clothes on?
At least she doesn't
Unfortunately.
have a feral twin
I
pregnancy.
sure do, brother, but this
She
steak
is a
is
feral grocery shopper. It's already in her name.
Oh, that steak is looking delicious, though. Not gonna lie.
for me, it's like a fucking turkey leg.
That is big meat.
Lauren is having a feral moment.
She's at medieval times over there.
I know, right?
Let that lady eat in peace.
Ooh, Wendy Bender, thank you so much for
yeah.
the 5
5
memberships
memberships.
gifted.
Yes,
What a
thank you,
name,
Wendy.
Wender
Wendy
Bender.
Why did I say
Wendy
Wendy?
Bono.
Oh, because I saw Wendy.
Wendy,
Wendy
yeah,
Bono.
Wendy Bono or
Wender
Winder Bender. Yeah.
Like Wendy
I like it.
Bender.
Whichever one is
Remind
accurate.
me.
Thank you very much. We appreciate that. I appreciate that. Especially because I had my hands full with this steak. So
Oh my god.
don't get your
Lauren.
steak hands on the laptop. I'm not touching it.
Oh man.
Steak hands?
Just the left hand.
Voice to text.
Right. And all the typos.
By the way, the answer to the poll was 95% yes. Laura will claim her records burnt in the fires.
Oh no.
Oh, I didn't see that poll. I voted no just because I wanted to get it off the screen. I couldn't figure out how to do it. So I didn't read it. I just voted no. So one of the no votes is me. It shouldn't count.
96%.
Oh my god.
Oh, where were we even on this thing?
Do you want
I
us to
hope
read
I'm
this
not the
more?
one who has stalled this stream. I didn't mean to. If it was me, I
A little
apologize
bit.
in advance.
Well, you and the steak.
Oh,
Mhm.
blame
I'm
Lauren's steak foot.
Lauren's eating.
Foot, sauce foot.
It's not a
Sauce
steak
puts.
foot, it's a sauce foot. Okay,
Steak
I'm dipping
hand.
my fries on it.
No,
Good.
fries.
I
Could eat
hope
the
that
fries.
Gingerbread watches these streams, and these are the moments that he cherishes the most.
Poor people.
Oh, Omar, you were mentioned at the end of the stream.
I was?
He did his impression.
But Omar's dead.
Oh, he can
then-
never do me
But
properly.
he didn't say your name, and then she said your name, and then he was like, "No, don't say the names. We're not gonna say the names of people we don't like." And
We don't
I
speak
was like,
ill of the dead.
You talked about Dave Neal and his kids. So what are you talking about?
Yeah. Also,
Oh,
I
he's
was.
talking about me.
Feral cat has been named after me. So
Is Gingerbread afraid of summoning me in some way by saying my name
yes.
Maybe.
too many times, like
Like
Beetlejuice?
Voldemort or Nee?
Yeah.
Beetlejuice.
Oh, I'm gonna be making a YouTube video, man. I'm gonna get my licks in. I'm gonna go over this Woodnick reply, and I'm gonna do it objectively and fairly, as has been my tendency during this entire coverage. And I'm gonna have my fun with Gingerbread. It'll be cool. It'll be good.
Spoken like a
It'll be
true
good.
corpse, man.
And educational.
Can't wait.
I actually don't remember where we were on this page either.
We had gotten through the emphasis part. I think we had gotten to.
This is added.
Yeah, we're probably down here in a paternity action such as this one.
In a paternity action such as this one, the statute must necessarily account for defending a paternity action that is falsely premised from its inception, even if more fees are incurred towards the end of the proceedings than at the beginning. Clayton invoked 25-809G in his responsive pleading and has since maintained the case was groundless.
Right.
Clayton sought an order from the court determining he did not impregnate Laura. If other relevant issues are raised in the petition response, the court shall proceed to resolve all relevant issues in the case pursuant to the rules of procedure applicable to family law cases. Somebody explain that to me, please.
I zoned out when you were reading. I apologize. I'm here. Where do you just?
I think
One
it's
person
just.
we were all like waiting for to answer.
Oh boy. It's just reiterating the fact that, what we really want here is a ruling of non-paternity. And in order to do that, you have to do the whole case. And regardless of whether the fees are, sort of convoyed up at the beginning or the end or the middle or perfectly distributed all through it, that's irrelevant. Like, if Clayton at the very beginning was pro se and he had to, drive to the courthouse to file something and that took like $4 of gas, and then he had to pay Woodnick a lot of money at the end. It's all the whole thing. It doesn't matter how it was spread out.
Oh, I agree. I've never.
That's the argument he's making here. Which
I never
think,
paid attention to that Gingerbread argument.
because
the
that was
one
an
where,
argument. Yeah, that was a point in the original appeal.
Yeah, but it was nonsense. He had every right to litigate the way that he did.
Mm-hmm.
And she was responsible for all of those costs. And the judge found him valid. It's not a valid argument. Just because she wanted to dismiss early on didn't mean that he didn't have the right to pursue the sanctions that he would requested in his initial
Yeah.
pleadings.
You
Yeah,
know what kind
because
of argument it is, though?
what's that?
A little bitch argument.
Oh, geez.
Yes, ma'am.
Because
Oh man, that would hurt my feelings a little
the
bit.
damages to Clayton in public were already done. You know?
Oh yeah, because if to that exact point, let's just say, because what Gingras is going to say is, but he has a civil remedy. Maybe he does, but he doesn't have to pursue a civil remedy. And so if he incurs damages in the family law case because he's pursuing sanctions that have been written into the Arizona family code over there, and that's what he wants to do, and he doesn't want to open up a brand new defamation, slander, whatever case,
Right.
he's entitled to do that. And that's
Yeah.
how he wanted to handle it, and that's what he did.
Yeah.
And it was less formal than civil court, meaning less costly. And Laura Owens should be very thankful that he chose not to do that.
Mm-hmm. He still could.
He can.
Yeah.
What's the statute of limitations there? I think like a year. He's got a little
I
bit
think
of time.
she's done some shit in the past year that he could probably.
Oh, there's new causes of action. Well, I don't know about the new causes, but on the old charges, I think that he still can if he wanted to.
Hmm.
Are you
Sorry,
joking?
I had a mouthful of steak again. My bad.
Someone made a mistake.
It's like in the middle of
I'm
your
still
throat.
eating my turkey leg, my cow leg, whatever you want to call it.
Right, Clayton was right to request the relief. Laura cannot claim her surprise or prejudice that she lost control of the proceeding once a responsive pleading was filed. Oh my. And then he cites a case where there's finding, what does it say? Finding no error in
No error.
trial, court's refusal to dismiss upon petitioner's motion to withdraw pleading because Arful 46 gives court broad
Yeah.
discretion. This is the broad discretion Omar was mentioning earlier. See also State versus Hansen, whether to grant a motion for dismissals within the sound discretion of the trial court. Very good. Once
I have a dumb question.
Oh, go ahead.
Omar, why is
Yeah.
the W in the brackets?
That's probably how the case law was cited. They put it in brackets, and so therefore they put it in brackets.
Why?
I have no other explanation why.
My
answer to that is I'm not sure.
I would assume he's including a sentence that didn't start with this word, and so he's capitalizing what once was a lowercase w.
Mm-hmm. I bet that's right.
Oh, you know what? That's probably right. It's something like that. It's something simple like that. It's not significant to the meaning of the sentence, I guess would be the point.
I gotta go to law school. Okay.
Yeah. But to this point, to this exact point, it's family law 101. That when somebody brings a petition that makes you a party to the case and you respond to that petition, the petitioning party no longer has the ability to unilaterally dismiss.
Mm-hmm.
Specifically because the respondent has the ability to seek damages based on being forced to respond. And so it's no longer a unilateral thing. Both parties have to agree to the dismissal. So it's like the stupidest argument. And it's been a stupid argument ever since I've heard it.
Yeah. Because
Laura
otherwise
Owens wanted to dismiss early on, and they wanted to keep it going.
Yeah, because otherwise petitioners could just sort of create all this lawfare and then just like open the escape hatch whenever they want and go around and intimidate people, intimidate everybody, and do all sorts of terrible things, right?
The general rule is you have every right to dismiss as a petitioner before anybody responds without permission from anybody. But at the second that they respond, you are now the other party in the litigation, and they have rights too. Mm-hmm. And if you want to dismiss, you guys both have to agree. That's just how it works. Yeah. That's how it works in civil law too. I don't understand what the disconnect is and why Gingras has made that argument.
Well,
because he didn't have a better one to make because he's losing.
I was got to say something.
Yeah. I mean, it's up to them.
Well,
you want me to keep going, Lauren?
Yes, she does. She got sauce on her foot.
Oh my gosh.
We need a little more time. We're good.
Once a party invokes the court's subject matter jurisdiction, The court has discretion to rule in accordance with the evidence presented. The petitioning quote, the petitioning party must be prepared for the possibility that the court will not view the evidence favorably to the petitioner, unquote. Exactly. Okay, Sundstrom. Approving award of sole legal decision-making to respondent without requiring counter-petition. Good. Put another way, an action for paternity is also an action against paternity. Whether Laura's positions were unreasonable at the beginning, middle, end, or all through the case, the court has broad discretion to award fees it deems reasonable. Exactly. Yeah, and that's the same thing. Whether the cost was in the beginning, middle, end, whether her misconduct was beginning, middle, or end, they can, the whole thing, it's one case, right?
Right.
All right. Section 4.
In other words, the entire trial was based on her conduct at the beginning.
Well,
and
Dave
I think
says we can pat ourselves on the backs. The only reason we're here is we called her bluff probably moments before she was going to fake a miscarriage. That's true.
Mhm.
hell yeah.
Yeah. Issue 4.
Lauren is stuffing her face with meat.
Dude,
As we
it's French
should.
fries now.
Oh boy.
I finished the meat.
That was a lot of meat. The trial court did not abuse its discretion in awarding fees for unreasonableness and other litigation misconduct after denying Laura's motion to dismiss. A standard of review, a discretionary award of attorney's fees will be affirmed if there is any reasonable basis for it. And there's a case that's cited. B, the trial court did not abuse its discretion by awarding Clayton attorney's fees. The main thrust of this argument is that Laura attempted to dismiss the case before Clayton incurred attorney's fees. Therefore, any fees incurred after her attempts to dismiss are per se unreasonable. The opening brief states in pertinent part. And then he's got a quote from the opening brief. If we can scroll down. I won't read the whole quote. We've been through the opening brief, but it's basically, yeah. This argument is particularly misleading considering the history of this case, both in terms of when fees were incurred and what Laura asserts Clayton should have done. First, both parties had already incurred attorney's fees resulting from the alleged pregnancy dispute before December 2023. Clayton consulted with counsel in the early stages of the paternity action and paid associated fees. Although Clayton attempted to represent himself for some of the OOP and IAH, then we got to go to the next page, proceedings, he ultimately retained counsel for the evidentiary hearing on November 2nd, right, 2023.
Yeah.
We watched that. The court considered the OOP-IAH proceedings as part of the final evidentiary hearing in the paternity action on June 10th. And there was also the thing on February as well.
Yeah, and by the way, it wouldn't surprise me if he incurred fees before that, because even though he was representing himself, he did a really damn good job as a pro se.
Yeah. Yes, he
He
did.
seemed real well prepared. It would not surprise me if he had gone to Woodnick or some other attorney and spent money for a consult getting prepped for that hearing, because he did really well.
I think that's what they're saying. They seem to have some sort of citation for that. But I mean, yeah, that's fine. Okay, discussing stipulation of parties for court to review OOP-IH hearings. Clayton's challenges to the validity of the OOP and ultimately declining to award fees associated with the OOP/IH proceedings. Clayton incurred more attorney's fees and costs leading up to Laura's first motion to dismiss. And then there's a citation for that. It is true that most of the attorney's fees were incurred after December 2023. Sure. Laura's conduct being the primary reason. Burn. But flatly asserting the fees were literally zero when the case was scheduled for administrative dismissal is literally false. Very good.
This is my favorite part.
Clayton incurred fees in the IH matter and for legal consultations and costs before December. We got to scroll.
The part where he said literally zero and literally false.
Yeah, literally zero, literally false. That is a zinger. Laura's assertion that counsel could simply have called and talked to her is similarly anachronistic. Laura hired an attorney. Yeah, who talks on the phone anymore? Laura hired an attorney, Ms. Platter, prior to filing the paternity action. Although she did not formally appear in the case, this attorney was actively communicating with Clayton on Laura's behalf.
And sent him a C&D.
Okay. Yeah. Another attorney, Mr. Lopez, our good buddy Josh, represented Laura in the OOP-IH matters through October and November 2023. Clayton's counsel first appeared in the IAH case and directed communications through Mr. Lopez. Right. Clayton's counsel entered appearance in the paternity action on December 12th, but would not have communicated with Laura while she was ostensibly being represented by one of the prior lawyers. By December 22nd, Ms. Linval had appeared on Laura's behalf. Okay, she tried. On December 29th, Laura hired another attorney, Mr. Keith. Oh, he tried. After Mr. Keith withdrew on March 12th, Laura hired her current attorney, Mr. Jingy. Throughout this time, Clayton was not in any position to speak to Laura directly, nor she him, because of the OOP and IAH orders. The point of this history is that Laura was nearly always represented by counsel in some capacity. There was never a meaningful time Clayton's attorney could just pick up the phone and talk with her about the case. More importantly, even in December, Laura was still discussing the pregnancy, despite now asserting that she knew she miscarried on November 14th, 2023. Oh, no. Oh. And then they compared the citations for reference, which is good. Citation needed. There it is. From Laura's December 8th, 2023 article on medium.com. Oh no, medium.com has entered the chat. I won't be sharing updates regarding the status of my pregnancy with Clayton. I kindly ask not to receive congratulations or engage in discussions about Clayton and my pregnancy, unquote. If Laura truly believed the trial court had a duty to end the case in December 2023, she could have filed a special action. And then there's a citation for State versus Meza. The proper vehicle to challenge the denial of a motion to dismiss is not an appeal, but a petition for special action. Interesting. If she was correct, as she argues, this would have avoided the subsequent proceedings. Instead, she deposed Clayton on February 2nd, 2024, and expanded the litigation through her disclosure and discovery antics. Bizarre motion practice and other conduct.
I gotta speak to that, man. As a family law attorney, when another family law attorney serves us with a notice of deposition, it's like the ultimate unnecessary escalation. Like, what are we doing? Why am I sitting here in a deposition with you? It's a custody case, dipshit. When you do that, it's like it's almost like the same thing with financial discovery, whatever. Like, why are we unnecessarily escalating this? It's like an informal hearing. You're not going to have a jury trial on this one, and they do that. And she brings up a good point. When somebody's represented, you can't have a conversation with them. Like, you got to be really careful, especially if you're representing somebody, you're going up against somebody that has another attorney. If you somehow have a communication with them without their attorney, you get in a lot of trouble with that.
Oh, big trouble. Yeah.
Yeah. And so the fact that she's been represented by attorneys like back to back, I don't think there was ever a time where she wasn't in this litigation, was there? She always had attorneys.
At a time or something. Like, it's been like short periods of time.
But not only was she represented, she's escalating litigations, calling depositions, filing motions. It wasn't like the super chill, parenting plan. We're just going to do the responsible thing. And, they were litigating. And for what? For something that she knew that was a wrap back in November. That's, I think, the tenor of what I'm gathering here.
Random question. If you were pro se and you're in a case like this, if you want to depose someone, do you just do it yourself?
No, you can. You just got to follow all the formalities of a deposition. You got to submit a notice of deposition. You got to serve it properly on the parties. If you're deposing like a government agent, you better go through the correct government channels. Otherwise, they will just quash your deposition notice. And you could waste a lot of time doing that. Like, the benefit of having an attorney is, like, we know how to do that. We just have the templates. When you're a pro se, you got to learn how to do that, and then you got to get it right the first time, because if not, you're going to have to start all over, and you're just wasting time. So you could technically do that, but most pro se litigants don't, because it's like it's just a big pain in the ass to learn the procedure to do it and then execute it properly and all those things.
Did Laura ever get my? Thank you, Omar. Did Laura ever get my pregnancy congratulations barbership quartet telegram?
Barbership?
Barbershop, my bad.
I mean, nobody wants to talk on the phone, so you got to send smoke signals or telegram, Morse code.
I thought that was the FBI.
Barbers.
The officers showing up for the FBI call. They were the barbershop twins.
Oh, the police
Chocolate!
department. Oh, jeez.
Didn't somebody said today was National Law Enforcement Appreciation Day?
That's
and I was
true.
like, it's Chance Day. It's Chance Day.
Oh no.
Appreciate your local law enforcement.
More chocolate bars. Oh dear.
Okay.
I can't
so we get
believe
to-
this is how I'm spending my Friday night. I just want to point that out.
Well, what are your other options?
I can believe it. That
Well, I could be playing Madden. I could be having well, I guess I could have a whiskey anyway.
Well,
You're right. I
guess-
don't have a lot of
I mean,
I'm
other
not gonna stop
options.
you.
I don't know if you're any good at Madden, so maybe you shouldn't be. You know,
Oh, I'm better than you. I'm not better than you at Fortnite, though.
Is that soccer?
I'm ass at Fortnite, so that's saying a lot.
Football, I think.
No,
I mean,
Madden
yeah,
is football
Football.
of the American variety, not European.
Yeah.
Right. Got
Named
it.
after John Madden, football
is that
announcer.
FIFA? Is that what's the soccer?
FIFA is the soccer,
Yeah.
yeah.
Okay.
Yeah.
Video game.
Okay.
What do you
we
want
get
here,
to-
Lauren? You want more of this, or
I can pick up from here. Thank
we're
you.
at the top? I think it's very important to go back over that first sentence, though, because there's this citation is good.
The here where it says expanded
Mhm.
litigation. Okay, let's see. Hang on. Instead, she deposed Clayton on February 2nd and expanded the litigation through her disclosure and discovery antics, bizarre motion practice, and other conduct. Meanwhile, despite Laura's current
No,
claim
no.
that
See, for example,
see, for example, motion to compel lunch. No,
zinger.
that's why I skipped the parentheses.
I thought for the longest time that people were joking about that, just like having a laugh. When I learned that was actually the title of an official motion, it's like, holy shit, never seen that before. Motion to compel lunch. I love it.
There was another one recently, wasn't there? I saw it in a headline somewhere, but that one was successful. I think.
There you go.
If I could remember it, if I suddenly it comes back in my brain, I'll let you know.
Like
but
a motion to meet and confer.
it was
Seen those
somewhere.
before.
No, it was called a motion to compel lunch, and it was somewhere north, but I can't remember which state.
Oh,
Okay. Meanwhile, despite
Wait,
Laura's current,
if you Google motion to compel lunch, the third result is the Reddit sub Justice for Clayton.
Nice.
of course it is.
Amazing.
JFC's made the big time. Number 3 on Google.
order granting, this was in 2006.
There it
There's
is.
one that was more recent. But yeah, there it is.
Very
I'm
good.
trying to remember if I could remember which state it was in. God damn. Wait, this was it. Was this it? In 2024? Hang on. This might just be like a recap or something.
Is this the one where, look, if the judge and the lawyers if they all know each other, it's a small town, and they're like, look, just go hash this out. Like, I can see this happening. You know what I mean? But this is not a situation like
No.
that.
Exactly.
But if judges are going to do that, they'll just tell the litigants to do that. Like, literally, we'll go
Okay.
into chambers with the judge
Yeah.
and we'll talk it out, or the judge will say, look, y'all go meet in the hall.
Mhm.
We're gonna take a recess, come back in 20 minutes. You guys can't work it out, then we're gonna come back another day. It's up to you guys. They'll just straight up tell you to do that. There won't be like a big formal thing. Is my
Go to the
point.
food cart and come back in an hour.
Judge
Yeah.
orders lawyers to have lunch to think about what they did.
Oh dear. Oh, maybe.
Plaintiff's
Oh,
counsel
no.
covers the bill, defense covers the tip. Okay. Just the tip. All right. Chief Judge David Proctor of the Northern District of Alabama, so it wasn't that far north, but it was north from me, recently issued a timeout to some attorneys appearing before him, ordering both sides to the lunch table. Welcome to the most awkward It's Just Lunch date ever. Motion to determine lunch spot. Number 4, it is granted defendant's answer in response to pleading shall be filed on or before January 6th. Further, the court orders that on or before December 31st, counsel for both plaintiff and defendants are to go to lunch together. Plaintiff's counsel will pay the bill. Defendant's counsel will leave the tip. The parties will discuss how they can act professionally throughout the rest of the case. Within 10 days of the lunch, the parties shall file a joint report describing the conversation that occurred at lunch and the amount of the tip. They should just live stream it.
They have to do a book report? Oh, man. How embarrassing.
I guess so, right? Huh. This was like less than 2 months ago.
Amazing.
Yeah, right. And that's so awkward. Also, how do you end up having to pay for the entire meal when the other person just has to pay the tip? Like, what if the other person like engorges themselves? You know what I mean? Like,
Well, maybe the petitioner was the more egregious party in the
Yeah.
misconduct.
Huh. Hey, Roz, what's up? Rosalind just got here. Also, let me check this really quick. K McBizrunner, thank you for the $10. Baby Jingy doesn't advertise family law on his bar page, if I remember correctly. After watching his incompetence in this case, at least we can point to one time he was honest. Thank you, K McBiz. All right. Let's see. Meanwhile, despite Laura's current claim that she was involuntarily forced to remain in the litigation, Clayton repeatedly offered to dismiss the case and withdraw all claims if Laura admitted she was not pregnant by Clayton and apologized. And she even got a last chance in court.
Yeah.
Even before filing her motion to dismiss, Clayton's counsel provided a simple affidavit Laura could have signed to end the case. The affidavit said, "I was never pregnant with Clayton Echard's child or children," and assented to dismissal with prejudice. Clayton's goal was not to torment Laura or run up attorney's fees. He needed confirmation, either in the form of a sworn statement or a court order, that he did not impregnate Laura to undo the damage her allegations had done.
Mm-hmm.
Obviously, she did not accept these offers, but she did threaten to sue Clayton for $1.4 million. Not this again.
The extortion claim, right? Yep.
Yeah, in a collateral action, unless he agreed to unconditionally dismiss in the paternity. Unconditional dismissal. Okay, in the paternity case. Wow, that she initiated and canceled her deposition. Jesus. Lastly, the opening brief asserts the amount of the fees is not reasonable because of the technical and procedural arguments being made, but it does not effectively explain any challenge to the amount of fees awarded beyond referencing the objections made below. Therefore, to the extent Laura asks this court to review the substantive application for fees on such grounds as the reasonableness of the hourly rate, the time expended, etc., the opening brief does not articulate those arguments. They must be considered waived.
Oh boy, you got to show your work.
I guess.
Get the Excel spreadsheet out.
So to the extent that Gingerbread is over there arguing that it was unreasonable for them to continue the litigation to pursue sanctions, he's straight up bringing the receipts of settlement offers that you normally are inadmissible. But in an appellate setting, you could talk about them. It's like, hey, he offered her on multiple occasions. All you got to do, admit you were never pregnant. Admit you weren't pregnant. And I'll drop the whole thing. There were settlement talks. There was offers to dismiss. It didn't work out. And then there was an extortion claim. And so then the thing continues. Once again, a failed attempt at, I wouldn't, how would you even categorize that argument on Gingerbread's part right there? The fact that they could have dismissed at any time and they wanted to keep this going. But then you have these receipts. Oh no, we offered them to dismiss a few times. All she had to do was admit certain things. It wasn't happening. And then, here we go. How would you characterize that argument on his part?
His argument is that why would my clients sign something that they don't think is true?
Yeah. Well, I guess that kind of gets to the heart of the matter because he thought that she was lying. She was asserting it the entire time. His character had been assassinated by her claims for many months prior to all the stuff that had come out. And so it was important for him to get to the truth of the matter. And if they weren't willing to admit it, then he wanted to litigate it, and he was well within his right to do that. And family law offers a mechanism to argue truth in that way. And that's exactly what played out in June.
Well, I think his argument is like, well, my client's not going to sign something they don't think is true. And then when there were no babies, we want this to just go away. Which, it's all refuted here in this response. I mean, I don't know.
Sorry, Dave says when Omar showed up, he had no idea. We appreciate you. And then somebody said, you have no idea. Like, I don't know who introduced Omar to this case, but I thanked them or something like that. And I'm just thinking, like, it was Laura.
Was it?
It was Laura. Laura emailed me.
You just got a random email, Omar?
I got an email from this lady. I want to say I got an email from like Justice for Clayton. And but I get a lot of emails like that. And so it's like, whatever. But then I got an email from Laura Owens, and that piqued my interest. And they're like, hey, you should talk to Dave Neal. Some other people. And then I messaged Dave Neal, hey, somebody said I should talk to you. And Dave was all, gave me the introduction into the case, and the rest of history. Had I known that it was going to turn into all of this, I might have just tapped out of all of this. Had no idea what I was getting into.
Too late for that now, sir.
Well, I'm in it now.
Hey, but you met us. Come on.
Yeah. I gained some friends along the way, and sometimes those are the small victories that you take with you.
Mm-hmm. All right. Where are we at now? Issue 5?
Yes.
Okay. This argument asserts Laura is entitled to fees on appeal because of Clayton's other conduct of aggressively litigating this paternity establishment action, despite knowing Laura was no longer pregnant. Laura's argument that Clayton should not have continued litigating after the alleged miscarriage is anachronistic at best, because no one other than Laura knew whether she was pregnant or when that pregnancy had ended. By the time of the motion to dismiss in December, only Laura knew about the 2 sacks. I fucking hate that. She passed in September or October or July 2023. She later alleged.
Oh no!
Only Laura knew about the October 16th, 2023 HCG test showing Laura had either miscarried or that a miscarriage was inevitable. On October 18th, Laura filed a request for pre-decree mediation, arguing Clayton even acts as if the unborn children don't exist. Well, despite a preponderance of the evidence. On October 24th, on October 24th.
I think your steak was preponderous.
I don't know what it was, but it's gone now. And November 2nd, Laura testified that she had a high-risk pregnancy, was 100%, 24 weeks pregnant, due on February 14th, and was being actively seen by doctors McCool and Higley, who she saw last Friday.
Page 60 is the last text page.
Oh, good.
On October 25th, Laura testified in support of the validity of the sonogram sent to Clayton and that she believed she was having fraternal twins, one boy and one girl. She also frequently, the lawyer admitted that she, did not ever get told by a doctor that she was having twins.
Yeah, that believing is more like wishful thinking, I guess.
Yeah. I mean, what if everybody put what they believed in court filings? All right.
Right? Yeah. There's 1 million gold bars in my garage.
I believe the children
I just
are the
believe
people.
it.
And one in your pants.
Ooh.
A gold bar?
That would hurt. That would hurt my junk.
That's what she said.
Ow.
Gold bar would just get in the way.
Yeah. There's not enough room.
This is terrible. Okay, this is terrible.
But the thing is the bar. That's the thing.
No!
See, it's not me dragging down the stream this time, Lauren.
Stop! Just stop. Okay.
Bruce is over there talking about his junk.
I will mute you.
Schnitzel's
I will mute you if you don't stop.
Schnitzel is
I'm going to
innocent.
mute all of you right now. Oh my God. Okay, moving on.
The hell are you doing?
I hate when I have to scream at you guys to shut up.
I feel like I just got scolded.
We did.
Okay. Okay. On October 25th, Laura
Next
testified.
sentence.
Oh, next one? Okay. Okay, yes. She also frequently stood up and rubbed what oh god, not this again.
What?
Stood up and rubbed what appeared to be a swollen abdomen while on video during one of these hearings. At one point, she asked if she could show her belly on camera to prove she was pregnant, including screenshot and timestamps of hearing. Okay, so they put that there.
Yeah.
And this was what date again? October 25th. Okay.
Yep.
In short, although Laura knew all these facts about the alleged miscarriage, she continued to assert she was pregnant in sworn testimony in court filings. Laura did not give any detail until the status conference on February 21st. Even in her December 28th motion to dismiss, she asserted she was not now pregnant without any further details. Clayton was appropriately skeptical of the assertion and asked for documentation. For example, if Laura miscarried November 2nd, a reasonable assumption given her testimony that day, the miscarriage would have resulted in the issuance of death certificates to the Department of Vital Records. By this time, Clayton was also aware of Laura's past litigation alleging a coerced abortion, an intentional infliction of emotional distress against another person. Laura later commanded the court to take judicial notice of that action, so its existence became part of the trial record. Yeah, why did she do that?
Once again, I have zoned out. Where are we at right now?
I think it was February, the early February hearing.
Yeah,
is when that happened.
She asked the court to take judicial notice of the Greg case, right?
Apparently, I mean,
I kind of vaguely remember that now. Yeah,
I'm not sure
Why was that relevant, though?
What the strategy was there. If they were trying to get ahead of something, maybe is the only thing I can think of. Like if they wanted to get ahead of Woodnick doing something.
Obtaining proof of how the pregnancy ended would certainly help to elucidate whether there was a pregnancy in the first place, and Clayton was entitled to that evidence. Okay. Well, when Laura moved to dismiss the action, Clayton had already filed his responsive pleading and made affirmative claims for relief.
That's a wrap. On that issue.
Yeah.
Not for the whole thing. For that issue, that's a wrap.
Clayton objected to the dismissal because his claims, including a determination about whether Laura was ever pregnant by him in the first place, still needed to be adjudicated. The court followed proper procedure when finding voluntary dismissal was not appropriate and maintaining the action to resolve the remaining claims for non-paternity, attorney's fees, and sanctions. And I call it this, Article 46, the petitioner loses the right to unconditional dismissal after a responsive pleading is filed. Voluntary dismissal after responsive pleading requires a motion and the court's approval. The court may dismiss a petition after a response is filed, but only on such terms and conditions as the court deems proper, including the resolution of any claims by the responding party. Here, the court determined dismissal was not proper because Clayton's claims needed to be resolved.
Right.
At that time, Laura's primary argument for dismissal was that the court lost jurisdiction once the pregnancy ended. It did not. Subject matter jurisdiction is established at the time of filing and cannot be ousted by subsequent actions or events. Jurisdiction, and he's citing some case.
Yeah.
Jurisdiction depends upon the state of affairs existing at that time it is invoked, and once having attached is not lost by subsequent events. Internal citation omitted. Okay. What is that? When it says internal citation omitted, is that like something we just can't see? Like what's happening there?
Well, usually sometimes when you read these cases, they're literally cited that way in Lexis or Westlaw.
Okay.
They omit citations for varying reasons because perhaps a case that they've cited is not relevant to the public discourse, and so they'll just take it out so as to not confuse people. But it's all agreed upon, and if you read that case in Westlaw or Lexis, that's exactly what it will say.
Okay.
That's all. Simple as that.
Arizona law favors retention of jurisdiction unless the divestiture can be clearly and unambiguously found. The only divestiture language in Clayton's counsel can find in the statutory scheme for paternity actions is in ARS 25-805, effective death, absence, or insanity of plaintiff. Well,
they could argue insanity of plaintiff.
They could, but they would lose. They would lose. They would lose.
I tried.
I know.
I'm doing my best for Laura out here. I mean, what can I do?
I mean, as always, right?
Yeah.
That statute permits the state to assume the petitioner's place in those circumstances, but is silent as to the effect of death of the unborn fetus or child. Had the legislature intended to abate paternity proceedings automatically in the event of a miscarriage, it certainly could have done so. It is not difficult to imagine scenarios in which continuing the paternity action after miscarriage is necessary and appropriate, such as for insurance claims or establishing the family's standing to sue for wrongful death. Conversely, in cases like this one, the putative father may have need to provide non-paternity even if the pregnancy does not end in live birth.
Exactly.
Yeah.
That's why I was saying, even if you have a miscarriage, you need to keep going and do like some sort of, tissue biopsy or something and figure out paternity.
Let's see. To the extent Laura argues the trial court's jurisdiction are automatically abated upon her allegation she was no longer pregnant, this argument must also fail.
Yeah, that's nonsense.
Attorney fees on appeal. Echard requests an award of attorney fees incurred on appeal pursuant to ARS 25324 and 25809G. Owens has maintained unreasonable positions throughout the proceedings. Her appeal, particularly regarding Rule 26 and the fee statutes, does not make colorable claims for interpreting or expanding the law. Instead, her appeal mostly seeks to misdirect this court with incomplete, inaccurate, and sometimes even substituted recitations of the record and precedents. Conclusion: the trial court the trial court admirably resolved this difficult matter and wrote a detailed, comprehensive, and legally complete judgment. The appellant has shown no reversible error. Clayton requests this court affirm the trial court's judgment in all respects, deny petitioner's appeal, and award respondent his reasonable attorney's fees and costs on appeal under, whatever. There's a certificate, and I think that's it.
No,
Yeah, all right.
Very good.
we did it.
You sent me something else. What was this?
Just in chat, it was the reference to the Greg Gillespie point that she was making. So it was from the 412 filing by her lawyer called Request for Judicial Notice, and then it has these points. I didn't get all the numbers in, but anyway, that's where it came from.
Okay, cool.
Oh wow.
So Woodnick was requesting judicial notice of those cases, not the other way around. Did I misunderstand?
No. Laura's lawyer was.
It was very confusing to me.
It was Corey Keith at that time, right?
Yep.
Wait, in April, it was Gingras.
Keith wanted to take. Gingras wanted judicial notice of the Gillespie case, but for what though?
Corey asked for judicial notice. Why did I think that?
He was talking about happening in February, right? I don't know.
Well, the case they reference, or the filing they reference, is, I can tell you with 100% certainty, it is this 412 filing.
412, yeah, okay. Oh, are they trying to say? Oh, was he trying to say because nobody technically won in the Owens Gillespie case in terms of what was it, the coercion and the emotional distress?
Right.
Maybe he's trying to say like nobody should win here. I don't know.
Here's the link to the filing.
Interesting.
And it's on the second and third page.
Okay.
Second. Yeah, the court finds that neither party prevailed under the unique circumstances of the case. They reference that at the end.
Sorry, I don't know why this is taking forever to load.
Oh my
That's
God.
good. She said.
Interesting.
Pardon?
Could be he's trying to just get the same result here. I'm not sure.
Can you refresh?
No, I like to watch the thing take away. I'm scared of refreshing. It might get worse. Look, it's over halfway done.
This is a big boy.
You're a
Oh, see, this is around the time. It's like the witching hour. Nothing good is going to come of the stream. Right now.
I refreshed. Oh no!
Oh no!
What did you do, Lauren?
No.
Why did you do
Lauren,
that?
I don't
did.
want your porn history to pop up. Please, please, X out of whatever this is.
It's loading immediately for me.
There's no more gold in my pants. She's on hotel Wi-Fi.
You guys are balls. I don't even know what else to say.
You guys are
Lauren,
balls.
it's not my fault. Schnitzel's over here trying to get me in trouble. Bruce is talking about his junk. I'm getting scolded by Lauren.
How am I getting you in trouble?
Well, because you were encouraging me to say whatever I was saying. I don't even remember what I said.
What were you saying? Well, see?
Wow.
But you were playing instigator. That's what I remember.
No,
That's all I remember.
never.
Hang on, let me hold up this-
Troublemaker coercion.
Never.
New lawsuit.
I sent you a screenshot on Discord, Lauren.
Yeah, let me
if
see.
you want to show it.
Oh my God, this is taking forever to load too. Hang on.
I don't know if we're going to learn anything.
God. Oh my God.
My learning capacity is currently at 0. I'm not here to learn anything.
Do you want me to read it?
Yeah.
Wonderful.
It says, to summarize, Ms. Owens asked the court to take judicial notice of the following points based on the information provided. And then there are 9 points. One, on August 21st, 2021, Ms. Owens filed a civil action in Maricopa County Superior Court against an individual named Gregory Gillespie. Two, in her complaint, Ms. Owens alleged she and Mr. Gillespie dated briefly. She became pregnant with Mr. Gillespie's child. And after learning the pregnancy, Mr. Gillespie subsequently used, quote, verbal and emotional abuse, end quote, to coerce Ms. Owens into terminating the pregnancy, which she later did. Three, Mr.
Time out. Was this when he did this to try to make an argument that they can't be witnesses?
No, this is before. I think this is before that.
Okay.
This was before the motion in limine.
Yes. Yeah, before that. The
Oh.
opening to it's just to support
Oh,
her
now it
position
works.
either at trial and or in future dispositive motions pursuant. Okay. Petitioner Laura Owens respectfully asked the court to take notice of certain records reflected in the table below because Ms. Owens has supplied the court with the necessary information to support the request. Judicial notice is mandatory, not optional. Quote, the court must take judicial notice of a party requests. The court is supplied with necessary information. Judicial notice of documents is proper. Also, to avoid any misunderstanding about what this request means and what the court is being asked to do, Ms. Owens merely asked the court to take notice of a prior proceeding, Owens versus Gillespie, which she was a party. In doing so, the court may take notice of the existence of the allegations in that case and how those allegations were resolved. At the same time, court is not being asked to find that any of those allegations were true or false because doing so would be improper. So
I feel like what he was trying to do here is combat this idea that was in some of these early filings from the Woodnick firm in both cases about how there were these similar past cases.
Mm-hmm.
So I think what they're trying to do here is say, oh, no, these cases are totally different.
Mm-hmm. Yep. I think you're right.
But they're not. It's stupid to do that because the underlying reasons behind all of it, they're going to find common threads in all of them.
Whether it's a good idea or not, I'm thinking that's why they did it.
Yeah, I mean,
ahead of the thing.
But it's not what he thought it was going to do. If anything, it's highlighting that there are similar cases out there with different fact patterns that led down the same Golden Brick Road. Golden Brick Road, is that what it's called?
Well,
Yellow Brick Road.
Yellow Brick Road.
I agree.
Follow the
Maybe
Golden
the
Brick
wizard
Road.
grant Omar a brain. Jesus.
The thing I've noticed is that, Owens and her attorneys can be very pedantic when they think it suits their case. And I think this was an instance of them being very pedantic about details and missing the forest for the trees.
Yeah.
Pedantic sounds pervy.
That's what happens when you spend your life in civil law and try to get into the weird ass world of family law. What are you going to do, man?
People are strange.
Oh boy.
All right, it is time for me to go to bed, guys. I have an early morning tomorrow.
Oh, will you share the thing about that?
If you want to see this filing or listen to this filing without all the clowning in between, without the clowning in between, though, this one's only an hour and a half long. You can go here to Schnitzel Ninja's YouTube page. I'm gonna put the link in the chat. Hang on.
Schnitzel's gonna be reading it in a cat voice.
I should have.
Okay. That's totally what's gonna happen.
The whole time.
Video here.
For an hour and a half.
I'm linking the video in the chat. So if you listen to her read it, it's consecutive, comprehensive review without all the talking. It's literally half as long as the stream was. So, all right, right there's the link in the chat there.
And the thing about that is that any money that I make from monetized videos is donated 100% to the victims. So even if you don't want to hear this again, but you in some way, just an easy way, want to give a couple cents, probably
leave it on the background.
Just click on the video.
Yeah, that's it.
Couple cents, quite literally.
Very cool.
I can tell you when I do this video next week, I promise I'm not going to be reading this word for word because I've already bored myself. So I'll zone out way too many times. I'm just going to go over the highlights, man.
Literally both times she asked you, you're like, yeah, sorry.
Well, I don't know what your problem is, but I had a meal. I did some light cleaning. It was
some cleaning.
I actually liked reading this filing more than I thought I would. I thought I would get real bored by all the legalese and the case citations, but I think the way he wrote it made it very interesting.
I thought it was really well written.
Yeah.
Yeah, it is. I mean, I would have read it a lot faster. A lot of that stuff just felt like he was reciting basic law. Well, I was just kind of looking for the highlights, but that's kind of why I was zoning out. I was like, oh, you said something. All right.
I'm on a stream right now.
I mean, I'd rather have them dot all the I's and cross all the T's. You
Yeah,
know.
well, he had to. He did what he had to do. But yeah, I
Yeah.
mean, it was well written, and I felt like it was an easier argument to make. It was like where logic takes you. You don't have to make these big, grandiose technical arguments to support the position. Just point to the case law, and there's mountains of it, and that's what he did, which was what I was expecting, and I was not disappointed.
Yeah. So there's going to be another response, and then it sounds like they're going to file a motion to have oral arguments, which may or may not be approved. Is that how it works?
He says they're 100% definitely going to get approved.
I mean,
not-
no,
I'll
I'm
trust him
talking,
when he
I'm
says
talking
that.
about reality, not his speculation.
But I'll tell you what, I mean, I don't practice in Arizona, but if he says that it's standard practice for them to have oral arguments, fine. I could tell you in California, it isn't. Like
Yeah.
30% of those oral arguments are granted.
Okay.
And so if it's different in Arizona, I guess I'll take his word for it.
I'm not taking his word for anything.
The word I read was probably.
I mean, I would not say definitely 100% anything, but sure, probably this
Well,
being
to
a
me,
high profile
probably
case.
means more than 50% likelihood. I don't know if
would
oral
agree with
arguments
that.
in these kind of appeals in Arizona have greater than 50% or not, but whatever. I think it's
I mean,
just
what
his
is the
opinion.
big
He's entitled
if-
to his opinion, but
yeah, but if this was not like a case of public interest, like what would be the big legal conundrum that we're solving with this case such that we need oral arguments to fix it? Like so many of these arguments are like family law 101. What's the point
Okay.
of the oral argument? Like if there's no merit, if there's not enough merit on both sides, what's the point of oral arguments? That's usually one of the factors that goes into it. But I am cautiously going to take Gingras at his word when he says that 100% of the time oral arguments are going to be granted. All right, I guess we'll see. I'd be disappointed if they weren't. I want to hear him argue.
well, I mean, what I read was probably. I don't know.
Well, you read correctly. You read correctly the same thing that everybody else read. But Gingras speaks a different kind of a way. Gingerbread over there.
Mm-hmm.
Yeah.
What kind of frosting do you think he uses? You think he's a pink frosting kind of guy?
Oh, no.
No, white.
He probably uses fondant.
Of course, it's white. Fondant.
Fondant.
Fondue.
Fondant.
I don't like
I've never
fondant.
known him to pronounce that word, man. That's not even frosting. It's like taffy. Like, what is that shit?
It's
It's
gross.
like not even. Yeah, I feel like it's like cancer-inducing, sugar-filled creation from the nether regions. Nobody wants that stuff.
What?
What are we talking about?
I would rather
Marzipan.
lick the sauce off of this carpet than listen to you talk about genital fondant.
I wasn't even talking about genitals. I said the netherworlds. The
No, you said the
nether
nether
region.
You said the nether region.
Well, that's not what I meant.
What are you supposed to mean when you say something like that?
I think genitals would be a subset of the nether regions.
Listen, don't get all technical
In
on
set
me.
theory,
It was a pervy thing to say, sir. Don't even give me that.
we will
You've
apply
been saying
science
perfect
to
things
this.
all night, man. I've been holding back.
Oh, and
It is
I'm
Friday
the
night. It's
instigator.
like
Okay.
10:43.
Lord.
Now I want some marzipan.
There it is.
Oh, Jesus Christ, man.
Did anyone hear that?
No?
Well, okay, that's good.
What?
is happening?
Nothing.
Wayward noises.
I just ripped a huge fart. I was gonna say it.
That's what you were alluding to. But now there's no more mystery, so.
I'm in danger. Are we done?
Yeah, we're.
I think so. I'm gonna go pass out.
I'm in
All right, I gotta go. Bye, everybody. Thanks for coming. We'll see you next time.
Oh my god.
Ready for your thoughts?
Jesus
Says I
Christ.
heard it.
No.
And we had heard it. People did hear it.
Oh.
I love you guys anyway.
You're welcome. You're welcome.
Bye, everyone.
Bye.
Y'all have a good weekend.